All right, I will call this meeting of the Senate Judiciary Committee to order. Will the Secretary please take the roll?
Senator Flores.
Present.
Senator Orenshaw.
Here.
Senator Lang. Senator Wynn. Senator Hansen. Senator Krasner. Senator Ellison. Chair Scheibel.
And I am here. Thank you so much. We will go ahead and get started. I do intend to take the bills in order this afternoon. I will open up the hearing on AB 35.
Good morning, Madam Chair and members of the committee. My name is Aaron Ford, and I am your Attorney General. Here simply to introduce the bill, Senate Bill 35, Senate Bill 35, which will be discussed by my colleague and Chief of Prosecutions, Alyssa Engler. We beg your indulgence. She has a court appearance right after this, so we're going to try to get in and get out if that's okay with the chair. With that, Alyssa Engler.
Thank you, General Ford, and good afternoon, Chair Scheibel and members of the committee. For the record, my name is Alyssa Engler, and I am the Chief Deputy Attorney General for the Criminal Prosecution Division at the Nevada Attorney General's Office. Thank you for this opportunity to present Assembly Bill 35 to you this morning. As drafted, Assembly Bill 35 was a bill that sought to protect children in the rapidly growing and changing world of artificial intelligence. This bill previously included language that would prohibit the distribution, production, and possession of computer-generated images or images altered by AI that depict a child engaging in sexual conduct. These types of images are not currently covered by existing law prohibiting child pornography. However, Senate Majority Leader Cannizzaro sponsored a bill, SB 236, that likewise addresses this topic. Attorney General Ford fully supports the Majority Leader's bill and testified alongside her before this committee. That said, there's one component of AB 35 that was not addressed in Senate Bill 263. A very important language change needed in statute. In that regard, the current statutory scheme in NRS prohibiting sexually explicit images of minors refers to the crime as either child pornography or pornography and a minor. While all understand what these terms mean, the language does not always accurately reflect the crimes being committed or the harm done to the victims of these crimes. To better articulate the crime and its harms to both victims and the community at large, AB 35 seeks to change references of child pornography in NRS to child sexual abuse material. This is not just a simple change in nomenclature. The word pornography connotates constitutionally protected speech containing images or videos of sexual activity between consenting adults. A minor cannot consent to sexual activity, therefore the current terms in NRS do not properly underscore the criminal nature of these activities. I want to be clear that images and videos of the sexual abuse of children are crime scene photos, and our statutes need to reflect that. Amending these statutory terms to child sexual abuse material is important to focus on the actual crime against children, to recognize the trauma inflicted upon children by these images and videos, and to underscore the absence of consent, control, and choice for these child victims. This change in language is something that is happening across the country. 7 other states, Arkansas, Maine, Montana, New Hampshire, New Mexico, Utah, and Vermont have adopted similar laws, and the United States Department of Justice adopted the language in 2023. I'd like to thank the chair and the committee for considering AB 35 as amended, and I'd be happy to answer any questions that this committee has. Thank you.
Thank you so much. Any questions from members of the committee? I am not seeing any questions this afternoon. So thank you so much for your presentation. And we do understand if you have to leave for your court appearance, we will go ahead and move to testimony. And if you're still here at the end and want to make closing remarks, we would welcome you back if you're available. But at this time, we will move into testimony in support of AB 35. Anybody wishing to give support testimony in person is invited down to the front here in Carson City or in Las Vegas. I don't see anybody coming forward, so we will go to the phones for a support testimony on AB 35.
Thank you. If you would like to offer testimony in support of AB 35, please press star 9 to take your place in the queue. There are no callers wishing to offer support testimony at this time.
All right, then we'll move to opposition testimony to AB 35. Anybody wishing to testify in opposition is invited to the front of the room now, but I don't see anybody moving in Las Vegas or well, you guys are moving, but you're not coming to the front of the room in Carson City and Las Vegas. So we will go to the phones for opposition testimony on AB 35.
Thank you. If you would like to offer testimony in opposition to AB 35, please press star 9 to take your place in the queue. There are no callers wishing to offer opposition testimony at this time.
Okay, then we will move to neutral testimony on AB 35. Anybody wishing to testify in neutral is invited forward to do so now. I don't see anybody coming to the front of the room in either of our in-person locations, so we'll go to the phones for neutral testimony on AB 35.
If you would like to testify in neutral to AB 35, please press star 9 to take your place in the queue. There are no callers wishing to offer neutral testimony at this time.
All right, then that brings us to the conclusion of testimony on AB 35, and unless our presenters have any closing remarks. All right, looks like they don't. Then that brings us to the conclusion of our hearing. I will close the hearing on AB 35 in what may be record time. We'll have to go back and check. But I am pleased to open up the hearing on AB 63 and invite our presenters up to the front.
Good morning, Chair Scheibel and members of the committee. My name is Aaron Ford, and I am your Attorney General. I'm accompanied by two of my colleagues. My Chief of Post-Conviction to my right is Heather Proctor, and in Southern Nevada is one of our colleagues, Jamie Stills, who will be testifying and explaining this particular bill. I want to say at the outset that we have accepted as a friendly amendment one from Clark County. I believe Mr. Frierson is going to come up during testimony and discuss that particular amendment, and I will just simply say it is to reiterate that this particular cause of action does not endeavor to assign fault or blame relative to any law enforcement officers that were engaged in the underlying actions that are at issue relative to this particular type of cause of action. But with that said, I will leave the further discussion to Mr. Frierson in that regard and turn it over now to my colleague, Ms. Heather Proctor. Well, is it Heather Proctor? All right, Ms. Stills. We're going to have Ms. Stills go.
I'm sorry, before you do that, I did receive an amendment on behalf from Mr. Frierson on behalf of JLM Holdings. Okay. Yes.
Mr. Frierson said he'll address it.
Okay, my apologies. Please, go ahead with your presentation.
Thank you, AG Ford, and good afternoon, Chair Scheibel and members of the committee. For the record, Jamie Stills, J-A-I-M-I-E-S-T-I-L-Z, Senior Deputy with the Nevada Attorney General's Office. In 2019, the legislature created the wrongful conviction compensation statutes codified in NRS 41.900 to 41.970, which authorize a person who is not currently incarcerated for any offense and who was wrongfully convicted and imprisoned in the state to bring an action for damages and other relief in any state district court. Since its creation, the Nevada Attorney General's Office has worked with claimants in balancing the state's obligation to be fair and just with its responsibility to ensure that it is not overwhelmed with enormous monetary liability. To that end, the office ensures every claimant complies with NRS 41.900 and establishes by a preponderance of the evidence that they did not commit the crimes for which they were convicted. The cases are always presented to a state district court who will ultimately decide whether to issue the certificate of innocence, attorney's fees, and any monetary awards. The intent of the wrongful conviction compensation statutes, as addressed in the 2019 legislative history, is to provide monetary support for persons recently released from prison or parole to permit them to begin rebuilding their lives and to re-enter society, and for the state to do what it can to restore their dignity and life after years lost wrongfully convicted. An award does not place blame or find fault. Rather, the person is provided a chance to live a normal life with a certificate of innocence that allows the claimant to move forward with money and assistance to restart their lives, and without the wrongful felony conviction looming in their background and at every traffic stop. AB 63 seeks to clarify the existing law on 3 points. First, we added a definition for the term incarcerated. In our amendment submitted in the Assembly Judiciary, we reversed the alteration of the original language in NRS 41900 sub 1 regarding the term incarcerated, and instead added the definition in section 1. That new definition defines incarcerated as a person confined in a local detention facility, county jail, or state prison. The new definition clarifies any confusion for the parties or courts as to the initial qualifications for an applicant to seek wrongful conviction compensation. That is because NRS 41900 sub 1 is a preliminary requirement that a person must meet before filing a wrongful conviction compensation complaint. The reason for this requirement, again, goes to the intent of the statute, to permit those wrongfully convicted to resume a normal life outside an in-person custodial situation. A person who is currently incarcerated, as now specifically defined, does not face the same difficulties as a person who is released to society and must rebuild a normal life. The term incarcerated appears only in this portion of the existing wrongful conviction compensation statutes. All other references regarding custody status use the term imprisoned. The term imprisoned is largely accepted to refer to a person under a sentence in the Nevada Department of Corrections. LCB also altered a term in section 2, subsection 4 of the bill to change imprisoned to incarcerated. That alteration is consistent with the new definition found in section 1. Second, section 1.5 of AB 63 addresses the standard a person must meet to qualify for wrongful conviction compensation. NRS 41.900 subsection 2D requires a person meet one of 3 criteria. Under these provisions, a person must have their judgment of conviction vacated, charges dismissed, and the basis for vacating the judgment was not legal error. The issue we found in litigating these cases, however, is that the requirements in subsections D1 and D2 are not clear. This reading of the current statute is in line with other provisions of NRS 41900, which require a person to prove that they are actually innocent of the original charged offense and any acts associated with that original offense. If a judgment is reversed for legal error, that does not mean that the person is innocent of those charges. We therefore seek to amend subsection D to clarify the distinction between the first and second criteria as they exist in the current law. We believe this clarification will assist recently released persons, their attorneys, and the courts in understanding the criteria required in order to qualify for compensation. Third and finally, the remaining changes to section 2 of the bill seek to amend the awards and benefits a person may seek in a wrongful conviction compensation action. This section has 2 changes. First, a person who receives an award for wrongful conviction compensation is entitled to a monetary award of damages based on the number of years served in prison and/or on parole. A person may also receive other monetary benefits, such as assistance with tuition, housing, counseling, and health insurance. Both the damages award and the benefits are paid upon approval of and by the Board of Examiners. As detailed in NRS 41.950 subsection 2B, the statute specifies the board provides payment for the cost of these benefits. Section 2 alters the term payment to reimbursement. This change reflects the original legislative intent as borne out by the current practice of the Board of Examiners to reimburse for actual expenses the person already paid out for such benefits, rather than direct payment to third parties. Second, in 2021, the legislature created subsection 6 of NRS 41.950, which applies a maximum to the benefits outlined in NRS 41.950 subsection 2B that a person can receive. The cap is set at $100,000 per calendar year for a length of time equal to the period the person was wrongfully imprisoned. The cap was intended to include all monetary benefits. In other words, all money reimbursed in such cases other than the initial damages award and attorney's fees. However, that amendment contained a clerical error as the miscellaneous provision, any other relief, should have been included in the $100,000 cap under subsection B. The 2021 amendment inadvertently created a separate category of reimbursement. The proposed amendment now corrects that clerical error by moving the catch-all any other relief provision under the $100,000 cap for benefits reimbursed in any calendar year. As AG Ford mentioned, we anticipate Cornerstone Public Affairs is submitting a conceptual amendment that the issuance of a certificate of innocence and award does not constitute a finding of wrongdoing. That is a friendly amendment, as the amendment is consistent with the no-fault nature of the wrongful conviction proceedings and the issuance of a certificate of innocence and award. Thank you. That concludes our presentation of AB 63, and we are happy to take any questions the committee members may have.
All right, thank you so much. And I apologize, I think we are having a little bit of confusion internally about amendments to this bill. I understand that an amendment was proposed, accepted, and adopted on the Assembly side. I received 2 proposed amendments to this bill that I did not post to Nellis because they did not come from the sponsor. Is the sponsor, did you intend to submit any amendments to this bill?
Aaron Ford, for the record, beyond the one with Cornerstone, no. The 2 amendments you're talking about, I'm not even familiar with. I don't believe they presented them to our office for consideration, and so this is the first I'm hearing of them.
Okay, thank you. So the one amendment that you are accepting is a conceptual amendment from Cornerstone on behalf of JLM Holdings?
Yes.
Okay, I will have that one uploaded to Nellis, and we'll follow up on that. Right now, let me see if there are any questions on the bill itself. The amendment's very small. On the bill itself. I'll start with Vice Chair Flores.
Thank you, Madam Chair, and it's always great to see you, Attorney General Ford, and your amazing team. I have a couple questions. So, in looking at NRS 41.900 and in the bill's section 1.5, subsection D, originally as it reads now, there's 3 triggering prongs, right, that you could either utilize, and it sounds like we're collapsing 1 and 2, and we're trying to make that read a little bit more clear. My concern is, and I'll just maybe put it together in the way of a hypothetical, just so that I can really try to get to the essence of my concern. Suppose that Nevada citizen gets convicted of a felony, they spend years in jail, and then afterwards, and I'm just going to use the word technical error just to make it clear that it didn't go to the essence of innocence. We find out that there's a technical error. Now, if there's a technical error at that time, and there's a reversal and dismissal, and not a retrial, in that scenario, my understanding of how AB 63 reads now, that individual would not be entitled to the remedies of NRS 41.900. The reason I'm making that point is I'm concerned that the district attorney will not have any incentive to want to retrial a case if there's a technical error, so that we don't open the door to this remedy that's available under NRS 41.900 through 970, because both can be true. You could have, Nevada citizen could have been convicted of a felony at that time and then had it reversed and dismissed based on technical error, and also that he was innocent or she was innocent, but because we never have a retrial, that person will never get an opportunity to make their state that they were also innocent. So I'm just concerned that we're putting all the power on the district attorney's hands to decide whether or not we're going to have a retrial. And if the district attorney decides not to have a retrial and simply say it was based on technical error, this person will never get an opportunity to get their bite at this apple. So could you walk me through that? Or maybe I'm misreading it, and maybe I need a point of clarification on my end.
Thank you, Madam Chair, direct.
Please go direct.
Thank you. As I'm going to ask Jamie down south to respond to your question.
Thank you, AG Ford, and thank you for the question. It's actually a really great question. The intent of NRS 41.900 and these wrongful conviction compensation actions are to compensate folks who were actually innocent. So it really isn't intended to correct or ameliorate any kind of situation where there was a technical error. But there is a separate function under NRS 34.900 that allows for persons who feel that they were wrongfully convicted, who are actually innocent, they can pursue an actual innocence petition. So in your scenario, somebody whose conviction was overturned due to a technicality could still pursue an actual innocence petition under 34.900. And if they were successful, then they could pursue a Chapter 41.900 wrongful conviction action. And that would help to make them whole if they were in fact actually innocent, in addition to the technical error.
And thank you for that clarification. Really appreciate that. Madam Chair, if I may go into a different section of the bill. Specifically in reading page 4 of the bill, where we're in NRS 49.950, where we're changing the word payment to reimbursement. My concern there is, suppose the same hypothetical individual gets convicted for a felony, they've been in prison now for 20 years, it gets overturned. When they get out of that system, wraparound services, money, resources, jobs, everything's out the window. This person's pretty much starting from zero. And then on top of that, in order for them to be able to get this remedy, assuming that they have the resources and the know-how and find the lawyer that's going to help them go through all this so they can get these statutory damages, that's probably going to take anywhere between 3 to 7 years, depending on how this plays out and how quickly they can make this happen. I'm just trying to figure out how that individual will front all those expenses. They're trying to go to a trade school. They're trying to find additional housing. They're trying to make their whole life whole again on their own for a few years. And then once they finally, hopefully, get the statutory damages that they're eligible for, now they're 5 years in arrears and expenses, all these different things, and then moving forward, they're still expected to have to front everything and then give the receipts. And so I'm just curious to know what it is that the thought process was there, and then typically how quickly does it take for an individual after they submit receipts to get reimbursed?
For the record, Heather Proctor, Heather, Procter. I believe there's some confusion. There's a couple of different award components in a wrongful conviction action under 41.950. The first is the primary award, which is based on the length of years served in the Department of Corrections and or on parole. Once that award is approved, that is paid immediately once the Board of Examiners approves that award. Then there is the attorney's fees. The $100,000 cap and the reimbursement versus payment is for the additional benefits that are awarded, such as the housing and the counseling. So they do have a lump sum that they start with following the receipt of the award. We are changing this to reimbursement versus payment, as the Board of Examiners simply does not have the resources to track when and pay direct to the individual vendors for tracking the $100,000 award for these individual benefits, and to pay those vendors directly rather than reimbursing the individual for those costs.
And thank you for that. Since 2019, or better said 2020, when this was enacted, how many cases are we talking about between 2020 and 2025? Do we have that number by any chance?
For the record, Heather Proctor.
It looks like we might be having some technical difficulties with Las Vegas.
Once again, Heather Proctor, for the record. I will do my best to respond. I believe we've had 12 applications since 2019, when the wrongful conviction statutes were enacted.
And thank you for that. And the reason I asked that question, if it's been 12 individuals in 5 years. I just don't know why it would be so incredibly difficult for us to help those 12 individuals and say, look, for you 12, and assuming that's the same amount of number, we're going to continue moving forward. Every 5 years, we're averaging about 12. Just assuming we stay with the numbers that we're looking at now, that we couldn't potentially consider allowing them the opportunity to say, look, I'm going to go to this trade school, I've enrolled, but I need to pay this now, and if you could help me with that. But that may be a procedural and technical nightmare internally. So please, maybe you could just shed some light on why that just would be so difficult.
For the record, Heather Proctor. This change was requested by the Board of Examiners, who handles these reimbursements. This is the process that we've been using since the beginning, was this reimbursement process. And we have not heard any difficulties from claimants on that point. Beyond that, I would have to defer to the Board of Examiners.
Aaron Ford for the
And
record.
if I may?
Yes, go ahead.
Sorry, AG. Thanks, AG Ford. For the record, Jamie Stills. Just to address that concern as well, our understanding with the Board of Examiners is that it would actually be an even longer process and would take even longer to pay these if the Board of Examiners had to do a direct payment for school, to a therapist, to a literacy program, different people who run literacy programs, to the health insurance that the claimant selects, to whoever is in charge of housing for that claimant. Trying to process and get all of these third-party vendors certified would take a lot longer. I believe it's a current every quarter. It might be semi-annually that the Board of Examiners does reimbursements, but I think it is quarterly, and that is a much faster, more expeditious process of doing that reimbursement quarterly than it would be trying to get all these third-party vendors certified, paid out. It would just be a much bigger logistical nightmare, and it would take much longer. So the reimbursement rather than direct payment is actually for the claimant as well, because it does get things done faster.
Perfect. Madam Chair, I know I am hogging the mic. I know there's a few other things that I wanted to ask about, but if I could just ask about one thing in reference to the definition on incarcerated.
You can ask as many questions as you'd like.
Appreciate it, Madam Chair. The only other question is, and I do appreciate the definition of incarcerated, to make it clear we're not talking about house arrest or when some individuals may be on parole or whatever it may be. But under this definition, if an individual is wrongfully convicted and then they're now released, and then they get placed in a civil detention center afterwards, so not for criminal matters. Let's say they're in the Henderson Detention Center on a civil matter and they're detained. Would they be, through this definition, denied the opportunity to seek the 41.900 through 970 relief year because they're technically in a local detention facility, even if it's unrelated to a criminal matter?
For the record, Jeannie Stills. My understanding is that that would likely disqualify them. Obviously, it would be case dependent and we would have to assess what the specific situation is. But the whole purpose of 41.900 is to actually help people who are out in the community get back on their feet. So somebody who is detained is not out in the community and would not at that time need assistance such as housing, medical, that type of thing that they would if they were released. Obviously, if they did become released from the detention facility, then they could pursue a wrongful conviction claim. If they were not incarcerated when their conviction was overturned, they could pursue it at that time. As long as they were not incarcerated at the time they filed the complaint, then they're fine.
And thank you, Madam Chair. And the only reason I asked that question is because I know that hypothetical is in fact in the universe now, where individual was convicted of felony A, the case was overturned and then immediately put on a civil, in detention center on a civil matter. And in that scenario, had they been, under this definition, what's concerning is, or in general, just as it reads now, in the ideal world, they can immediately pursue this remedy so that upon getting released from there, now they're not starting from zero with no resources. They took advantage of those 6-7 months to put themselves in a better situated place. So this is not for us to agree to it now. Just for food for thought, I would appreciate the possibility of maybe in that definition excluding a civil hold, so that we make it abundantly clear, even if they're in a local detention facility under a contract, a federal contract, that they still would be eligible to pursue this relief. And again, this is just food for thought to think about it, process it through the team, and not necessarily something that we have to agree to or disagree to now.
And actually, I think our legal counsel might have some insight on this.
Thank you, Chair. Yes, I just wanted to point out that that sentence actually says a person who is not currently incarcerated for any offense. So the for any offense would exclude any kind of civil hold. It has to be for an actual offense that the person is in detention or in prison.
Any further questions or follow-up? All right, then we will move to Senator Orenshaw.
Thank you very much, Chair. Thank you, General Ford, for presenting the bill and your amazing team. Chair, with your permission, may I follow up with a quick question on that civil hold to our legal counsel?
Of course.
Thank you. Then we've seen an exponential growth in ICE holds in the news. It's all we hear about. Let's say someone is no longer in a local detention facility, county jail, or state prison under the language here in Section 1, but there's an ICE detainer, an ICE hold. Do you think they would be precluded then if they were wrongfully convicted from pursuing this or not, based on being in ICE custody?
Well, that's a good question. I'm not really sure how you would characterize that, if that's actually more of a civil issue than a criminal offense.
And maybe that's something we could get back to us on, if that's okay, Chair, with you. I do have one question for the Attorney General and his team. Looking at Section 1.5, I'm on page 2 of the amended bill, going down to the new language under sub D 1 and 2, that now, the basis for reversing or vacating the judgment of conviction was not legal error that was unrelated to his or her innocence. The judgment of conviction was reversed or vacated. And I'm just thinking of a hypothetical. Let's say there was a judgment of conviction that was vacated due to maybe the prosecutor had not disclosed some exculpatory evidence to the defendant, or there was judicial bias found on the magistrate who presided over the trial. What do you think would happen if AB 63 passes as is under this framework? Do you think that person would still qualify, or would there need to be a new trial, or let's say I wonder if someone could discuss that a little bit.
For the record, JD Stills. Our position is actually whether under the current iteration or under this mandatory iteration, they would not qualify for reimbursement under NRS 41.900. This is more of a clarification, but our understanding is that this is currently still how we assess these cases, is that the overturning of the conviction does have to be related to the person's actual innocence. So even if this amendment doesn't pass, that is still our understanding of the language based on the legislative history. Someone does have to be actually innocent, and their conviction does have to be overturned based on that innocence in order for them to qualify. So the short answer is that no, they would not qualify under this amendment, but the longer answer is that we would not believe they would qualify either under the current iteration of the statutes.
Thank you, Chair. I may have another question after others get to ask questions, but thank you.
Okay, I'm going to move next to Senator Wynn.
Thank you, Chair. I want to thank the Attorney General and your entire team. I know that you've answered quite a few questions that I've had as this bill has been moving through the other side and then also onto into our House. And I did have a chance to review what I think is the only amendment from Cornerstone, and I appreciate that. I appreciate not having the election like options and some of those things. I know that I've seen, and I'm sure members of the committee have seen, some high-profile decisions that have come down, mostly from our federal courts regarding judgments and orders and rulings that were pretty high monetary amounts. Would you see the proposed changes in here, would they be applied retroactively to avoid payment to those people that have already been issued those judgments?
Aaron Ford, for the record. Senator Wynn, the answer is no. It would not apply retroactively.
That's my only question. Thank you.
All right, I will now go to Senator Krasner.
Thank you, Chair. Thank you, Attorney General Ford, for being here today. I appreciate it. I did have a question. It kind of follows up on my colleague, Senator Flores' question. As I look at Section 2, subsection 2B on page 4, where the word payment is taken out and the word reimbursement is put in, I can't help but looking down at 3 and 4 on that page, programs for reentry into the community. It would seem that we would want to pay somebody in advance who's just being released after being wrongfully imprisoned to take these programs for reentry into the community, because it doesn't just benefit that person, it benefits all society. And also number 4, counseling services for the person that was wrongfully convicted and now being released. Again, that doesn't just benefit the person, but it benefits all of society. And I think we've brought other bills that address those things, and we've all agreed as a legislative body that benefits not just the person, but every member of society. I just wonder what your thoughts were on that, sir.
Aaron Ford, for the record, we don't disagree relative to providing those services, Senator Krasner. And, you know, as a member of the Board of Examiners, I can't tell you how difficult it is oftentimes to get things done on the board because of the bureaucracy that is required. I have someone in my in the audience here, Teresa Jess Thompson, who I won't put on the spot, but if she likes to come up and tell you about the processes for having someone certified as a vendor for the state in the first instance. That can take months. Having that individual go through whatever processes are required in order to be able to receive payments. I mean, this is the type of thing that could, as Ms. Stills has already indicated, really slow the process down for the person reentering society. And so, as my colleague, Ms. Proctor, indicated, they're going to receive a lump sum of money in the first instance, $100,000, for example. They can utilize some of that money to pay for these services and immediately submit reimbursement forms to the Board of Examiners, which will be quickly reimbursed. And that's the approach that we have been taking, and the one that we would just like to codify on a going forward basis. Because frankly, it's going to take more time for us to be able to pay for, at the outset, counseling services and reentry programs if we don't go the reimbursement route.
I think Senator Hansen had a question. Go ahead.
Thanks, Madam Chair. The DeMarlo Berry case, I mean, that's when this all, I think, originated, 2019 session. You mentioned there have been 12 applications. Does that include DeMarlo's case? And of those 12, how many actually ended up being reimbursed?
Ms. Stills, if you want to chime in on that one, it'd be great.
Thank you, AJ Ford. For the record, Jamie Stills. I believe it is actually, at this juncture, we now have 13 because we recently had a new case filed. There have been 13 cases, and I believe out of those, 8 have been reimbursed, and that does include DeMarlo Berry's case.
Thank you. Now, do they have to get a certificate of innocence before they can apply?
For the record, Jamie Stills. The certificate of innocence comes through this action. So somebody files a complaint for wrongful conviction compensation under NRS 41.900. And if they qualify, if they meet all the statutory requirements, then they receive the certificate of innocence and the award and reimbursement.
Okay, good, thank you. But looking at the difficulty, it says if the person who'd been wrongfully convicted, perhaps, has to prove beyond by preponderance of the evidence all these steps. Going back to Senator Flores' question, how do they afford that? Okay, obviously you're going to need an attorney. I noticed also in section 2, I think it's 1.5, a judge may give them an attorney. So I'm just kind of wondering, the difficulty of, first of all, you've been convicted improperly. Then in order for you to access the fund, you have to go through all these hoops, and you have to prove, the state doesn't have to disprove, you have to prove that all of the things they accuse you of were wrong. I mean, it's a really complicated process to try to essentially make somebody whole who very likely was improperly convicted. I'm just wondering, there's a fairness factor there in my mind. A poorer person's not going to be able to number one, do these steps. Probably they're first of all, they're going to be delighted just to be out of the mess they found themselves in improperly. Secondly, I bet the majority of them would just I want to get as far away from the criminal justice system as possible. I'm not going to try to go back and recoup anything. I just want to get away from this mess. But if they do decide to, how the heck can they afford to do it in general? I mean, the only people that could actually access this type of a program and these funds would almost have to be wealthy in advance to be able to go through all the steps and get an attorney and fight this thing out in court to prove they were innocent at the time. So when I look at all this, it looks nice on paper, but I'm just kind of wondering how the heck, an average person who really has truly been convicted unlawfully can use this program.
Thank you, Senator Hansen. I'm going to offer some prefatory remarks and then offer my colleagues an opportunity to chime in. In the first instance, I just want to reiterate that that's current law. That's nothing that we are attempting to add to the current requirements. That was frankly, a policy decision that this body made when you enacted the statute, that you were going to require people to apply and go through a process in order to obtain a certificate of innocence. To your point about the difficulty in paying for the process, this statute does have an attorney's fees provision, so that if they prevail, they can get attorney's fees refunded, and that is something that I think is an incentive at some level for attorneys who are interested in these forms of actions. And we've seen in the 8 actions, I'm certain the attorney's fees have been a part of the recovery process unless they've been negotiated out. So again, it's an issue that's a policy issue that you all determined early on that this was a process that you want people to undertake, because the alternative is to open the floodgates for anyone to make a claim of actual innocence and clog up our systems, and me coming to you and asking you to give me 20 more DAGs to take care of all of the caseload that would accompany a process that was more liberal than the one that you've already articulated. So those are my initial thoughts on the process. And I will say this just real quickly before I give it to my colleagues, back to Senator Flores' point about we had 12 in 5 years, maybe we'll have 12 in the next 5 years. I don't think so. I think what had happened, remember, if you recall when you first passed this, you gave 2 years for individuals who had been incarcerated, who had been wrongfully convicted, to bring the action irrespective of the statute of limitations. And so we had an onslaught, so to speak, of applications that came in, and we have processed or in the process of processing those now. We do not anticipate in the next 5 years 12 more necessarily. These just don't come that far and few between, that frequently, and they in fact will be far and few between on a going forward basis. At least that's my estimation. And so again, let me afford Ms. Stills and Ms. Proctor an opportunity.
Before you go to her, though, I just want to make it clear, look, I knew that was existing law. This is not a criticism or anything.
Yes,
I'm delighted to hear, though, that we're not going to have 12 more over the next 5 years. We're hopefully getting it to a tiny minimum, and I'm glad to hear that those 12 may have been backlog cases from previous situations.
Yeah, and we actually saw a lot
forward,
of.
That's very rare. So.
I apologize, didn't mean to cut you off. We did see a lot of people right up on that statute of limitations. When the 2-year statute ran, a lot of people filed right on that deadline. And we've seen, my team could verify this, but we've seen a trickle since then of cases coming in on wrongful conviction actions.
Well, that's great. Actually, obviously we don't want any, but the fact that even one could exist, I mean, I want to make it as fair as possible. And when somebody really has a DeMarlo Berry type situation, we absolutely want to make them whole. But I want to make sure also the process policy that we've already set up has a mechanism in it to, really allow them to do that. And after hearing the hearing and listening to Senator Flores' comments, I'm kind of, I wonder, there may be some additional policy tweaks we need to do to make sure when these terrible situations happen that we really do have the law favorable towards the person that has in fact been unlawfully convicted. So thank you for your presentation, and thank you, Madam Chair.
Thank you. I think Senator Ellison also had a question. Go ahead.
Thank you, Madam Chair. Thank you guys for being here, because it's quite interesting. I'm not a lawyer, but I do have some questions based on my colleagues. And if, say, something comes forward that is not, like a technical, somebody witnesses or whatever comes forward, versus DNA, do they still have to go through a full trial to show their innocence, or is there something in there that says DNA proves that he was innocent, he couldn't have been there, so therefore he's probably released? That's my first question. And my second question is there a cap on the amount of money that somebody that was incarcerated can receive?
For the record, Heather Proctor. These cases do not have to go to trial. If we find going through that section 1.1, which is 41,900, if we find in evaluating the case that they have met all of the criteria, then we can enter into an agreement and submit to the court a proposed settlement in order to issue that certificate of innocence and the award of damages. In terms of your second question regarding the cap, the amount that is compensated is found in section 2. The first part, section 1A, details how much an individual is entitled to receive based on the length of their incarceration or time on parole. So that's the initial award. As far as the benefits, that's that $100,000 that is applied to the benefits listed in subsection 2B of that section.
I think that qualifies a lot, or says a lot, because if somebody has DNA that comes forward, or they found DNA, then I think that is a good way to say, okay, you're innocent, and move forward. So thank you very much.
All right. I think we have one more question from Senator Nguyen. Go ahead.
I just kind of have a follow-up question about the amendment by Cornerstone. Would this change in the definition that the entry of the certificate of innocence and that award under NRS 41.950 and that specific distinction, I'm assuming what you're going for is that is not a finding of wrongdoing against anyone involved in the investigation, prosecution, or conviction of the person, and is not a finding that there was no probable cause to arrest or charge the person. Do you find that to preclude that individual's ability to continue a civil lawsuit in federal court against those named individuals?
Thank you for the question. Aaron Ford for the record, and I will offer my colleagues an opportunity to chime in as well as Mr. Frierson. The answer is no. It does not preclude. It just does not give the presumption that a finding of a certificate of innocence is also a finding of wrongful conduct on behalf of a police officer or lacking probable cause to arrest. The plaintiff will still have to prove that case. Bring forth evidence to support that particular element of a cause of action under 1983. Does that make sense to you?
It does, and I guess I'm looking at some of the more high-profile cases like the Lovato case and that $34 million court award jury verdict, I guess, in that wrongful conviction. In that case, and I don't know, in that case, it's my understanding that they did not have to prove these violations by the Las Vegas police officers, it was just assumed in that certificate of innocence? Or, and then if this law was to pass with this amendment, they would actually have to prove that there was fabrication of evidence and there was those violation of those constitutional rights?
Well, thank you for the question. Aaron Ford for the record, and again, feel free to chime in, Ms. Stills or Ms. Proctor on this. They were the ones who prosecuted, and, well, that's not the right phrase, litigated this case, and ultimately we settled it. So when you say Lovato, I want to be certain you're talking about the case that we engaged in as the Attorney General's office as opposed to the 1983 action that took place in federal court.
I'm actually talking about the federal court 1983 action.
I will have to
I don't
leave
know
that.
if you-
I will have to leave that discussion to someone from the people who prosecuted or who litigated
I
the
don't know if
1983
Mr.
action.
Frierson might be able to answer that question because I think the amendment is set to address that, but is it possible to?
We'll invite you down to the front table if you'd like to discuss your amendment at this time, and even if you wouldn't.
I do secretly love this chair, so.
You do or I do?
I think we both do.
It is a very interesting conversation, and I think it is a very important conversation, and I appreciate that we're going to kind of drill into the details because that's our job, is to get the details right. So, Senator Wynn, if you want to go ahead and rephrase or reiterate any of your questions.
Would the proposed amendment, as proposed here regarding kind of that distinction that this certificate of innocence does not include a finding of wrongful wrongful action or unconstitutional action, does it preclude any of those 1983 actions against those same individuals and agencies?
Thank you, Madam. Thank you, Madam Chair. For the record, Jason Frierson with Cornerstone Group on behalf of Markey and Auerbach, and that amendment has been submitted to correct that. Through you, Madam Chair, to Senator Wynn. No.
Correct.
Thank you, Madam Chair. It does not preclude them. The point of the amendment is to clarify that the intention in issuing a certificate of innocence is to make somebody whole who was wrongfully convicted, independent of a determination of fault. So it could be fault, and they could seek some remedies based on that fault, but it could be judicial error. It could be ineffective assistance of counsel. It could be a lot of other reasons. And so the point is the certificate of innocence is intended to make someone whole, but does not preclude them from seeking remedies otherwise if there is wrongful conduct.
Thank you.
Any further questions or follow-ups on this topic? Okay. I think we've got our questions clarified on that. Any other questions on the bill in general? Okay, Vice Chair Flores.
And thank you, Madam Chair, for allowing me a second bite at the apple. I just wanted to, and I wasn't sure if anybody else was going to touch upon it, and I know I was hogging the mic. Assuming in that hypothetical that I initiated with where there was a technical error, and that we indicated that it wasn't the intent of the legislation in 2019, and with this correction of language now to make it abundantly clear that that individual would not be entitled to this remedy because they wouldn't be entitled to request a certificate of innocence. I was just curious to know how would, in that scenario, that individual pursue relief under 34.900? Well, what does that look like?
For the record, Jeannie Stills. What that would look like is filing an actual innocence petition under 34.900. Those cases are actually handled by the prosecuting agency. So for instance, if it was somebody who was convicted in the 8th JD, they would file a petition under 34.900, and the Clark County District Attorney's Office, as the prosecuting agency, would handle litigating the issue of the petitioner's actual innocence. And if the actual innocence were established and they were awarded, I believe it would be some sort of order from the court establishing actual innocence was proven. That would be something they could then bring to the AG's office showing their actual innocence and file a wrongful conviction compensation complaint.
And thank you for that. And how complicated is that process? So they they now had a case overturned under legal error, and then they go down this route. How long does that take? Does it involve a formal trial? Can you just walk us through that, what that process looks like?
Mr. Senator Flores, if I might interject real quickly, that frankly is a little bit beyond our area of expertise in that regard. We know of the statute. Ms. Stiles has been able to articulate the statute that they could use, but it would be something that's prosecuted or defended by, prosecuted is not the right word, but litigated by a different agency than ours. That said, however long the process would take, whether it's, quickly or, a while, they can immediately file a claim under the wrongful conviction statute and begin that process once they have in their hands a determination from a court that they are actually innocent.
Understood. And the only reason I'm asking is because as I'm reading NRS 41.900 in the bill under section 1.5, the way I read it now under sub D, it says any of the following occurred. The judgment of conviction was reversed or vacated, and the charging document was dismissed. That's what it reads now. That's sub 1. And then technically the semicolon says now or sub 2 or sub 3. So presently, as I read the bill, if any of the following occurred, the judgment of conviction was reversed, vacated, and the charging document was dismissed, in that scenario, in my hypothetical, that individual, I believe, would be captured because it was legal error, but this one's not differentiating. Now, if I read 2 on its own, where it says the basis of reversing or vacating the judgment of conviction was not legal error, that was unrelated to his or her innocence, and I read those as being separate because it says any of the following occurred, 1, 2, or 3. I'm just concerned that as written now, we're capturing that legal error, but if we move forward with this amendment, we're not going to do that anymore, and we're going to collapse 1 and 2 into 1, which is fine, because if that's the direction we want to move, because we want to make it abundantly clear that this was never intended for legal error, that's the only reason I'm focusing so heavily on 34.900, because I still want to make sure that we're creating a pathway for that individual to say, I understand legal error is why I won here, but I know that I am factually innocent, and I still want to make sure that I pursue that route. So rather than forcing us to go through that, because I know that wasn't necessarily what we prepared for today, maybe if you could just send me an email saying here's kind of what that process would look like under 34.900, because I just want to know how complicated it's going to be for that individual in that scenario to get their opportunity at getting a certificate of innocence and making their life whole by having some access to these statutory damages. So again, I will not put you on the spot on that. I'm respectful what the Attorney General Ford said, but I am interested in knowing that because that changes how I see this bill. If that avenue is still there, and there's going to be access to the court, due process, X, Y, Z, then understood. But if not, then I want to know that as well. Thank you.
For the record, Heather Proctor, if I could briefly address that. The actual innocence component is actually found in subsection E, where it says that the person shows that they did not commit the crime and had no actions involving that crime. So the actual innocence component actually is not impacted by subsection D. It's the subsection E where that actual innocence component is coming into effect. So the technical violation that you're referencing would still have to make it through these processes. Also, to clarify, we're not saying that they have to go through an actual innocence petition under Chapter 34 in order to apply for wrongful conviction compensation. They can come direct and file a Chapter 41 wrongful conviction action. It's just that they will have to meet all of these criteria, including that actual innocence component.
Okay, and Madam Chair, now I just realized I forgot to ask one question. And this one you've already addressed it. I just want to make it abundantly clear. In adding the language in page 4, any other relief under section 2, NRS 41.950, it's page 4. In moving that language of any other relief, you never intended to capture in there other relief sought, such as a 1983 lawsuit or anything else. You were specifically focusing on that catch-all for reimbursements, correct? But you weren't trying to cap an individual who may sue under different legal theories. You weren't trying to cap those, correct?
For the record, Heather Proctor, that is absolutely correct. The $100,000 is only for the benefits from a wrongful conviction action.
Okay. Any further questions from the committee? I know that we expanded a little bit on more than just what the bill does, but I do appreciate it, especially because this process is in, the history of the Nevada criminal legal system newer, and this is one of the first opportunities we've really had to get kind of an update. I'm personally fascinated to hear that there have been, 12 cases. I'm glad that my colleague, Senator Hansen, clarified it wasn't 12 cases that all happened at once, but we had a backlog because we didn't have a process before. So I consider this to be a really encouraging update in addition to a bill. So thank you for indulging us in this impromptu update on the wrongful conviction program or wrongful conviction factual innocence process. And we will now conclude the questions. And unless you have something else you want to add, please go ahead.
If I may be indulged to leave soon after this, I would like to make one statement before I leave, if you're okay with that.
Please, go ahead.
I want to give kudos where it's due. The two seated at the table right now have done yeoman's work on this program. It was not a program my office was set up to handle. I had to find a place to place it. I went to Heather Proctor, who works on post-convictions, and I just determined it was in the best spot. Someone who knows what she's doing, who I can trust, is going to be able to oversee a process that effectuated justice. And that goes back to day 2 on my job as Attorney General. Heather was there when I said our job is justice. And I said point blank, it's not just about a notch on the belt. Sometimes you got to get the bad people and put them in jail, to be sure. But sometimes systems make mistakes. And when you make mistakes, you must exonerate and compensate. And what we have done in this circumstance is effectuated justice 8 times out of the 13 so far that have been presented, and I'm so very proud of the work that Ms. Stills and Ms. Proctor and her team have done in this regard. And I also want to acknowledge Mr. Frierson, the work he's done to work with us on an amendment that has taken some time to get there. This is the first time we've done this, and there was an overlap between some causes of actions that have led to conversations around this amendment. He's been a gentleman in that regard, and I want to commend him and commend those who've been able to work with us in this process. And so with that, Madam Chair, thank you so much for allowing us to present this amendment on this bill. We will continue doing justice in the Office of Attorney General, and we will continue this work on the wrongful conviction statutes. So thank you so much.
Thank you. We certainly appreciate all of you and all of your hard work. At this time, I will open it up for testimony in support of AB 63. Anybody wishing to testify in support in person is invited down to the front here in Carson City or in Las Vegas. And we will start here in Carson City with in-person support testimony on AB 63. Welcome back.
Thank you again, Madam Chair. For the record, Jason Frierson. I think that we have made very well the point of the amendment, but I wanted to thank the Attorney General for allowing, along with your indulgence, me to be a part of the presentation in and of itself, but being receptive to the proposed amendments as clarification on legislative intent. So on behalf of Cornerstone Group and Marquis Narbach, I just wanted to be on record in support.
Thank you so much. I don't see anybody else coming forward in Carson City or Las Vegas, so we'll go to the phones for support on AB 63.
Thank you. If you would like to testify in support of AB 63, please press star 9 to take your place in the queue. There are no callers wishing to provide support testimony at this time.
Okay, we will move to testimony in opposition to AB 63. Anybody wishing to testify in opposition is invited forward to do so now. I don't see anybody coming forward in person in Las Vegas or Carson City, so we'll go to the phones for opposition on AB 63.
If you would like to testify in opposition to AB 63, please press star 9 to take your place in the queue.
Anne Marie Grant, Advocate for the Inmates and the Innocent, ANNEMARIEGRANT. I cannot support the bill because it does not go far enough. The Attorney General would not accept our amendment to include those who have suffered the ultimate injustice and died in prison wrongfully convicted. and therefore we are not in support of the bill. Thank you.
There are no other callers wishing to offer opposition testimony at this time.
Okay, we'll come back to Carson City for opposition in person. Go ahead.
Sorry, I was typing something. I may have I didn't hear it. Anyways, I'm sorry. Tanya Brown, TonjaBrown. We are in opposition of this bill and the amendment as well. Originally, the bill came through the Assembly Judiciary. We had put in some amendments in that. We did send it to the Attorney General's office. They were not in support of the bill, even though it was germane to the bill. So it never got heard. Okay, so we're bringing it back over this way. So it has, and I have spoken with staff. So what we had in our proposed amendment was under, let me see where I just wrote that darn thing down. In section 2, subsection 1A, to include a section 4, which is germane to the bill. If the defendant is found factually innocent posthumously, their heirs will receive compensation for the number of years the defendant had been in custody. When the members of the Assembly Judiciary had asked Attorney General Ford if somebody has been exonerated after death, are they entitled to the compensation? And he said no. That is a slap in the face to the families whose loved ones have been wrongfully convicted and have passed away. You are telling the families that we simply do not care. They are the ones who have suffered the most. Not only have their loved ones gone through the process of being wrongfully incarcerated, dying, now it's left up to the families to carry on. They are in need of compensation more so because now they've lost that loved one compared to the ones who are out and been compensated. They're able to spend time with their families. Those who have passed away, those families are left with no closure. And also, including in the amendment, we included, and this was kind of the issue that we were having with the AG's office, where they think it should stand alone, and that was like with the SB 66 as well. Exculpatory evidence that had been destroyed, hidden, and not turned over to the defense and was not available prior to trial that resulted in a wrongful conviction or prior to the defendant's death or after the defendant's death, newly discovered evidence is found. And we had put this under section 1.5, section 3C, and we included A and 2. And we had put that in the proposed amendment, and I'm hoping that now that we kind of cleared this up, perhaps you will look at our amendment now. But Attorney General Ford's office had seen the amendment. He said he hadn't. They had. Anyways, that's all I really have to say, and thank you. The more we can have discussions, I want to thank you for this discussion because a lot of things have been said, and the amendment, no thank you. Okay. And bring it forward. Thank you.
All right, not seeing anybody else coming forward to give opposition testimony and having already gone to the phones, we will now go to neutral testimony on AB 63. Anybody wishing to give testimony in person is invited forward now, but I don't see anybody coming forward. So we'll go to the phones for neutral testimony on AB 63.
Would like to provide neutral testimony for AB 63, please press star 9 to take your place in the queue. There are no callers wishing to provide neutral testimony at this time.
All right, thank you. That brings us to the conclusion of testimony. If the presenters have any closing remarks, we'd invite you forward now, but it looks like you do not, so we'll just thank you for being here and presenting to us this afternoon. We certainly appreciate it, and I will close the hearing on AB 63. I will now open the hearing on AB 283.
Good afternoon. Senator Scheibel, Chair Scheibel, and members of the Senate Judiciary Committee. I'm Max Carter. I represent Assembly District 12, the east side of Las Vegas, and the far north side of Henderson. And I'm here today with Jonathan Norman, and down south we should have Nick Haley available to present AB 283. AB 283 is a practical, common sense fix that makes the eviction process fairer without slowing it down. This bill would make our system stronger and more reliable for everyone, landlords, tenants, and the courts. At both the federal and state level across the United States, nearly all civil litigation follows a coherent and sequential order that I'd say that most Americans believe that's the way it's supposed to be. The complaining party files first, and the answering party files second. In Nevada's summary eviction proceedings, it's reversed. And so that's what this bill is trying to do, is move forward in reforming summary eviction processes. And we just want to bring back some fairness. And I will say that in the governor's veto message of a very similar bill last session, he sums it up with, since this bill makes Nevada an inhospitable environment for residential lessors, I cannot support it. I would argue that Nevada in general is a very, very favorable environment and a very, very sought-after environment for lessors. I grew up on the east side of Las Vegas in a community that was single-family residential and multifamily apartment complexes, but in the single-family residential areas, most all of the houses were owner-occupied. Now we've seen that we've shifted to where probably between 20 and 40% of single-family residential occupancies in my neighborhoods are owned by out-of-state lessors. So what I'm getting at is everybody wants into the market. We've got investment companies wanting to buy up the stock. Arguably, we have too hospitable an environment for residential lessors. And with that, I'm going to turn it over to my partner, Jonathan Norman.
Chair, Vice Chair, members of the committee, Jonathan Norman, NORMAN, with the Nevada Coalition of Legal Service Providers. We provide direct representation to tenants facing eviction or facing habitability issues between Northern Nevada Legal Aid, the Volunteer Attorneys for Rural Nevadans, Legal Aid Center of Southern Nevada, and the Senior Law Program. There's a lot of blue in this bill, so I have my copy, and I think there's 9 pages of blue language, but the bill actually makes a very, very small change, and the rest is reorganizing of the summary eviction section. So if you think of 8 or 9 pages of blue, and then there should be uploaded on Nellis 2 flow charts. One of the flow charts is our current process, and one is if AB 283 passed. So the summary eviction process right now, if you just think of a non-payment of rent case, the tenant doesn't pay their rent, they get a notice posted on their door that they have 7 days to pay their rent, vacate the premises, or file an answer. But no lawsuit has been filed, so that answer is effectively the first pleading, so they are being called to sue themselves in court. If they fail to do that on the next judicial day after, the landlord files a complaint, and at that point, the tenant has no opportunity to respond. So the complaint comes, and your opportunity to respond is over. And often we see these tenants coming to our office when they get a notice from the constable that they're going to be locked out. And at that point, there's nothing we can do. It's really scrambling with social services to rehouse those people and minimize the disruption and chaos to their lives. And if you look at the 2 flow charts, they're almost identical. So that's really what the bill does, is it's going to change the eviction filing order so that that 7-day notice goes, and on the 8th day, the landlord has to file a complaint, give it to the tenant, and then the tenant has a period of time to respond in the court by filing a pleading. And so that's the fundamental difference. And as you're looking, if you have that pulled up, if you look, the change is just these 2 boxes. Everything else in the process is the same. So again, even though it's a lot of blue, think of LCB reorganizing it because it makes it flow easier with the changes we wanted. I would also draw your attention, we do have a PowerPoint that was uploaded to Nellis. I'm not going to run through it here, but it kind of goes into a little more detail about the summary eviction process. And then there is also a letter from the National Housing Law Project. And just a few things to note there. Nevada is the only state in the nation where a tenant must file a lawsuit to defend themselves against an eviction. And eviction filings in Las Vegas, which is the only jurisdiction in our state tracked by Eviction Lab, are 30% higher than the national average. And when we talk about whether Nevada is conducive to landlords or not, Assemblymember Carter touched on that, but the National Housing Law Project said if passed, AB 283 will ensure that Nevada leaves its outlier status behind and meets due process standards accepted throughout the rest of the country. So I think it's important to think about that we are an outlier, not only in civil practice, but in evictions. And I will say other jurisdictions do have a summary eviction process. What is unique here is that the tenant has to sue themselves. And if they fail to sue themselves, their case is lost. And then, just to paint some context for what Nevada looks like, the Supreme Court publishes an annual report on the number of cases filed in this state in a variety of areas of law. And in summary evictions, you can count on around 85,000 cases filed every year. The vast majority of those cases come from Las Vegas Justice Court, around 75%. If you do, there are some folks who will testify with the Nevada Housing Justice Alliance who observed these court hearings throughout the interim since last session. And, I remember a hearing watching court. A few legislators came and Commissioner McCurdy came. And we kind of debriefed after watching a full docket of people getting evicted. And Commissioner McCurdy said 1 minute and 30 seconds. So he was timing the evictions, which I'd never thought to do, and he said that the evictions on that particular docket were 90 seconds long. Like, that's how long the tenant had in front of that judge. And to tell you why that, why this matters, that people having notice ahead of time and being able to prepare a defense matters, you would have people with their cell phones and they would say, I had a ton of habitability issues in my unit and the landlord refused to fix them. The judge looks at them and then grants the eviction, because that's how our process works. If they have an opportunity to get to legal aid and talk through the issues, there's a better chance that they're able to raise a real defense. And the consequences of eviction, when we talk about having stability in our neighborhoods, having stability in our schools, when a family is disrupted and is evicted, it's not like that's that moment in time and they're just magically rehoused and the kids in the same school, and if they had a neighbor who was the babysitter, that's still intact. It's a total disruption and can take years before that family is back on its feet. So with that, I'll turn it over to my colleague Nick Haley. He's an attorney at Legal Aid Center of Southern Nevada. He works on landlord-tenant issues only. So this is he's in the Consumer Rights Project, but that's the full scope of his practice. So he's dealing with hundreds of these cases all the time in Las Vegas Justice Court and other justice courts in Clark County. And then at the end, there was an amendment uploaded to Nellis, and I can just touch on that briefly when he's concluded. Thank you so much.
Thank you, Jonathan. Good afternoon, Nicholas Haley on behalf of Legal Aid Center, first name Nicholas, last name Haley. I am a consumer rights attorney with Legal Aid Center of Southern Nevada, focused entirely upon housing and landlord-tenant issues. In this past 3.5 years, I will reach my 1,000th case in about a month, so I have seen the eviction court more frequently than just about anyone. I'm going to walk through this succinctly, section by section. AB 283 amends NRS 40. This is a chapter of law, rather, that describes various judicial proceedings, including those for summary eviction. There's two main types of eviction. One is a formal lawsuit and the other is summary. Obviously, the summary process is a lot more popular because it is so quick. It is a possession-only type of action, so no money typically is awarded during such proceedings. It is just possession. Going to the actual italicized section, as Jonathan points out, this is really just a change of the order of complaint and answer, even though you see 8 pages of blue. The operative parts of this are largely section 3, which is on page 3 of the bill text, and section 6. Those are the ones that describe the complaint and the answer. The rest of this is largely unchanged from the current law that you would find in NRS 40 currently. So section 2 is the same as before, but it amends language to reflect the new order of events. Going to section 3 of the bill, we are looking at the first major change, which describes the complaint process. It gives a timeline for filing it. It also describes, to some extent, the manner in which it must be filed. So that combined with the subsequent sections you will see, 4 and 5, you see a service requirement. The way the process works right now is, as Jonathan described, it starts with a notice that is typically, it's
Sorry, if I can
in a
just
statutory
interrupt
manner.
for just a second. Jonathan Norman, for the record. I think Nick is describing section 2, and then he's teasing out the subsections, and he had said section, so I just want to make sure that's clear. So he's, I think, in section 2, and then subsection 3, 4, and 5. Thank you.
Yes, thank you for that correction, Jonathan. Nicholas Haley. I am going through the subsections. I'm giving page references too, so hopefully everybody can follow along. Subsection 3 is the one that describes complaints, and the subsequent sections describe the process for serving that complaint. This is basically a due process change, because currently the process begins with a notice that is typically posted on the tenant's door and mailed. This is not regular service like you would get in a lawsuit. It's mailed and posted. And there's a 7-day window for non-payment of rent cases. I would note that the subsection we're looking at right now on page 3 is just for non-payment cases. In a few pages, we get to a second process that's nearly identical, but goes for all cases that are not non-payment. These are things like nuisances, lease violations, anything other than non-payment. There's a separate process for that that's nearly identical. The main change to that is that there's 2 notices at the front. So that's why we have these parallel processes for non-payment and all other types of summary eviction. Going back to the subsections, on 3, we have the filing of the complaint. We have a process by which the complaint is served. So now we have service to the tenant, which is a major change here. It's something where before it would just be posted on a door and perhaps mailed. And depending upon the circumstances, we can get into that later, it may or may not be seen. So this would affect something resembling what you would expect of service in a regular lawsuit. As a side note also, I'd like to point out what Jonathan said earlier about this is the only jurisdiction where the answer precedes the complaint. It's also the only process in any section of law from what we can determine. In other words, in any field of law, this is the only one where the answer precedes the complaint in Nevada, in any jurisdiction for any type of issue civilly. Going through the subsections, largely these are just moved. There is the service requirement in sub 5. Going to 6, this is the other major change. This is the one that reflects the answer. I would note that the answer aside from being changed in order, the requirement does not change. It gives 7 judicial days, which is what it currently is. So the main change here is simply that once the tenant is served, they have 7 judicial days to file their answer. And there's some incidental changes regarding the language that the person that would be on the notice and would be on the complaint and would be on the answer. So there's a few in the other sections that reflect that, or subsections. Otherwise, Section 7 describes the hearing the same way. Section 8, Section 9 describe the potential rulings of the hearing master the same way. Section 10 describes the same proof of service that exists currently that has to be filed before the lockout can be effectuated. 12, 13, 14, all the same. Limits on the amount on the notice, those are all the same. It's just a shift within the statute, but otherwise the language does not change. You will see that there's an exception that's the same as before. The summary eviction process does not apply to commercial premises, and it does not apply to mobile home lots within a mobile home park. So if a mobile home park is suing somebody to evict them from a lot, it doesn't apply to that. That's the same as currently. Section 15 defines security deposit, no change there. Going on to Section 3, we have the, that is unchanged as well. That's the posting requirement. That process does not change either. Going on to Section 4 at the top of page 6, there is a post-eviction process whereby that deals with personal property of a tenant. This is a case where the tenant leaves, but perhaps they don't have all their possessions and they wish to come back to claim them because they weren't able to claim them within the timeline of the lockout. There is a process by which tenants can reclaim their personal property. There is also a statutory allowance for landlords to collect a certain amount of money based upon their actual expenses for the inventory, storage, and moving of personal property. So Section 4 describes that. That process is largely unchanged. Section 5 also deals with the disposition of personal property post-lockout. That process is unchanged. And then going on page 7, we have Section 6. This is the same exact summary eviction process. This is the one I mentioned earlier, is for all summary evictions that do not deal with non-payment. These are nuisances, lease violations, anything other than non-payment. And the main difference between these two processes is just that at the very beginning of the process, there are 2 notices that must be posted by the landlord rather than just one. Otherwise, this process mirrors the summary eviction process at the beginning of the Assembly bill. And to summarize, effectively, the change here is, number 1, the order of complaint and answer to be consistent with other jurisdictions, as well as to add requirements as far as how such complaint is served and the ensuing timelines for answering and filing a complaint. So to summarize, that is what AB 283 would do to amend NRS Chapter 40. And I think Jonathan touched on this a bit, where there are 2 main areas where this would potentially affect the due process rights of tenants. There have been circumstances we have seen in the past where bad timing can affect our client's ability to respond to a non-payment notice, sometimes even innocently. To give you an example, we're at the end of the month right now. Potentially, most tenants pay their rent at the beginning of the month. Many do so electronically. It is conceivable, and we have seen circumstances very similar to, I'll give you a hypothetical. Somebody pays their rent electronically. They believe the process was completed. They get a family emergency and leave town, perhaps even leave the country for a couple of weeks. They could come back and learn that the payment did not go through. They were served a notice after the 5th day. So May 5th of this month falls on a Monday. They could potentially get a non-payment notice posted on their door that day. And from that day, under the current system, they would have potentially 9 days to respond to that. The judicial days don't count weekends, so you would be looking at, for example, in the coming month, it could be May 12 would be their last day, and had they not responded to that notice by that time, there would be nothing they could do to prevent an eviction at that point. And it is very conceivable that a person could leave town for not an extended period, but even just 10 days, thinking that rent has been squared away, come back and they're evicted and there's nothing they can do to stop it. Because following that 7th day, the landlord could file a complaint, and there is nothing in the law that would allow the tenant to say, wait a minute, I thought I paid my rent, I intended to pay my rent, give me a chance to pay my rent, and I will do so. At that point, after the 7th day expires under our current system, potentially they could be locked out and have no means of counteracting that. And this, mind you, is on an informal notice process that includes mailing and posting. This is not formal process. So this is the vulnerability of the system and why such a due process change would be very significant to a lot of people. And I'll leave it at that. And
thank you, Nick. Chair, if I can just run through the conceptual amendment really quick.
Yes, and I think that we just posted it to Nellis, and so those members of the committee who are looking on your computers, if you hit refresh, you should be able to see it now.
Thank you so much, Chair. In discussions with the housing authorities, Jonathan Norman for the record, in discussions with the housing authorities, they said that they are required to give a longer notice period than we have in Nevada statute. So this is to accommodate their ability to still evict. So where we currently have it reading that after the 7th judicial day following service, so this is in section 2, sub 2A, or the day following, the amendment will add, or the day following a longer notice period if that period is prescribed by federal law or regulation. And then we also shifted the time the landlord has to serve to 21 calendar days from 15. And again, that was at the request of the housing authorities. Now, I don't want to say that this gets them to neutral because I believe they'll be here in opposition, but these were the changes that we thought made sense from those discussions. And I think
Max Carter for the record. I just wanted to sum up by talking about briefly about the experience at going to eviction courts in Las Vegas. You can see 2 different ways that it's done. One is it's very rigid and structured. There is accommodation made for landlords, meaning they can come in remotely, Zoom in, landlords and their agents, where the tenants must take a day off work, must pay for parking, must get into the courthouse. And that's where you see the 90-second processes go. There's another jurisdiction where either party's allowed to come in remotely and that the judge uses judicial discretion, which is appropriate, to work out a way to find a compromise to get things resolved. The difference is we've got an elected judge in one jurisdiction, we've got hearing masters in another jurisdiction that are hired and have to be responsible to their employer on whether they continue their employment or not. And it's very obvious. And what I see in this bill is it takes and moves some of that discretion out and puts it into the process and helps make the system more fair and also helps our court systems operate in a more fair system, in a more fair manner. And with that, we're open for questions.
Thank you so much. All right, members, who has questions? We'll start with Senator Ellison.
Thank you, Madam Chair. It used to be, I see in Section 3, used to be that, when they'd post a door, somebody would go over there and post a door with the witness and they'd sign it. Now everything's got to go to the sheriff or constable. Is that right?
Jonathan Norman for the record. I'm going to send that to Nick Haley, who's doing this work every day.
Nicholas Haley, for the record. There are multiple parties that may potentially serve. The eviction order is served by the constable, but the notices can be served by other parties, so it isn't just the constable.
Okay, there.
Max
'Cause usually
Carter, for the record.
yeah.
Typically, it is a contract company that you do it all online, and it is an employee of that company that goes out, puts a sticker on the door, verifies it, sends you a picture that they dropped the notice in the mail, and that's all that's required to satisfy the current system. It can be anybody.
Okay, thank you.
Other questions from members of the committee? Senator Hansen.
Thanks, Madam Chair. I got a bunch actually, but let's start with the time frames in this thing. I've been trying to figure it out, okay? You're the landlord, you give a 7-day notice, then there's 30 days for the tenant to respond, it looks like, in section 2. Then 15 days after that, the landlord, after the 30 days, I think, or during the 30 days, the landlord has to post another something for the tenant. Then there's an additional matter, 7 judicial days after that. Then when you jump to section 5, line 4, the tenant may request the court stay the execution. That's another 10-day window. Then you've got in number 6, the tenant shall within 7 judicial days after the date of service file a written answer. And then kind of the strangest one to me is section, what the heck section am I in? I'm sorry. Let me go back here. Section 2 still, number 7. If a tenant files a written answer pursuant to subsection 6, the court shall hold a hearing to determine the truthfulness and sufficiency of the affidavit of complaint for summary eviction. But there's no time frame. How quickly do you guys get into court to have a hearing like that?
Senator, thank you for the question. So I'll just start by, Jonathan Norman for the record, I'll just start by saying the only thing we're adding is those 7 judicial days for the tenant to file an answer. Any other timelines in there, like some of the longer timelines, those are at the discretion of the landlord. So, for example, the landlord has a certain number of days to serve that complaint. Otherwise, their notice is no longer good, right? So the landlord can do it on day 1, and I imagine most of them will, right? So that's not a change we're making that is causing more time for our tenants. And then if you can restate the last part of your question, I think there was...
The question was the time frame to get to a court hearing. You've got it in section 2(7), I think it is. If a tenant files a written answer pursuant to subsection 6, the court shall hold a hearing to determine the truthfulness. But there's no time frame. I noticed in some of the others you say within 10 days. In this one, it's open-ended.
Yep.
What is the window there?
Jonathan Norman for the record. So the courts get prickly when we tell them they have to have a hearing in a certain amount of time. And so we don't have it in there. I can tell you, and I see Nick with his hand down there, and I think when we presented in the assembly, these hearings were happening from, I think, start to finish within 30 days total for the total action. I know that coming out of the pandemic, the courts were backed up with cases, and that time period was pushing to 65, 70 days. That's not the case right now. I know the Las Vegas Justice Court, which is the busiest, they just added more dockets to the calendar, and we're able to, get it down to under 30 days. And I don't know, Nick might have, how the cases are right at this moment.
Well, yeah, what I'm getting at is I'm kind of wondering how many days. Okay, the landlord hasn't been paid his rent, obviously, whether it was, accidental because the guy ran off to another country and then his check didn't clear or whatever. But I suspect that's an exceptionally rare case. I would imagine most people can't pay the rent for some reason, and so the landlord understandably is trying to collect. And the way this thing reads, it seems like you could delay the summary eviction process for, a couple of months before, by the tenant getting after a certain number of times, they have 30 days to respond to it, and then you got a court hearing. I was like, okay, what is the absolute minimum time that somebody who is a landlord could legitimately remove an unpaying tenant? It looks to me like if somebody's a pretty sharp character, they can use these time frames to stay in a property for months before they could have a summary eviction.
Jonathan Norman for the record, and I'm just going to say one thing and then turn it over to Nick because I feel like his hand's been there for a while to answer. But the tenant has so this is section 2, subsection 5, A, and then I'm looking at A1. After not later than 7 judicial days after service of the affidavit for complaint for summary eviction, and then it describes, that the tenant must file a response within that period. So they don't have 30 days to file a response. If you can direct me to the section, I can clarify.
In section 2, number 4A, an affidavit of complaint for summary eviction filed pursuant to subsection 3 must, except as otherwise provided in subsection 12, be filed with the court not later than 30 calendar days after the expiration of the notice period described in subsection 2. The notice in subsection 2 is a 7-day window. So I'm confused on the time frames in all this.
Thank you, Senator. So that section 4A is how long the landlord has to file the complaint. So I'm assuming landlords are going to do it on day one there. They're not going to wait 30 days, but they have up to 30 days to file.
Okay, so they gave the 7-day thing, they put the notice on, they got 7 days, then following that 7 days, they got up to 30 days.
Yeah,
but that's the landlord, not the tenant.
Yeah, they can file it on day 8. And the reason for that is sometimes landlords and tenants are in communication and getting along, and maybe they've are trying to work things out. There's a reason landlords wouldn't file on that 8th day, and I'm not going to tell them they have to file on the 8th day or they lose their ability to file. So they have that period of time, and if they said they needed more time, I guess I wouldn't mind giving it. I think that and Nick can correct me, that Las Vegas Justice Court, if there's no action, they'll kick those cases out after 30 days. But Nick, can you jump in on that?
I think I got the answer though. That's kind of where I was going with it, because look, the landlords are the bad guys in this whole scenario. But most of the time, all the landlords really want is to get paid, and I don't think that's that unreasonable. And then all these steps to delay the payment. I went through something very similar in 2010, 2011, when we had the whole situation, people being evicted from their homes. And in fact, Senator Jason Frierson, myself, Hammond, the legislature set us up to meet with the Supreme Court, trying to come up with a way to keep people evicted from their homes, even more significant than I think a rental situation. And we came up with all sorts of hoops to jump through. But when the whole smoke cleared a couple of years later, we went back and looked at it, the people were still getting evicted. All what happened was there was just a significant delay in time, and ultimately that was paid for by the next person who purchased the home, because the banks added that cost into the thing. All right, quickly, section 2, number 13. You guys have in there, a landlord shall not refuse to accept rent from a tenant that is submitted after the landlord or the landlord's agent has served a notice, So they go and serve the notice, the tenant, but in the meantime, the landlord has collection fees, attorney's fees, other costs other than rent, a reasonable charge for late payments or dishonored checks or a security deposit that he may have incurred as debt himself. But the way you guys have this thing structured, the landlord is forced to just simply eat that, apparently. Or is the tenant at any point supposed to make that right if they haven't paid their rent, and the landlord has to go all through these processes to try to collect the rent?
Senator, I'm going to Jonathan Norman for the record. Send that to Mr. Haley down in Las Vegas.
Thank you, Jonathan. Nicholas Haley for the record. The reason we split this is non-payment notices are for an uncontested amount. Nobody disputes that rent is owed. These other fees can be contested, and until they're adjudicated, it would be unjust to evict somebody who's disputing whether or not these fees ever should have been applied. This is why we bifurcate those two costs. They are still recoverable, just under a different process. If, in fact, these fees are determined to be legitimate, then they can be recovered as potentially a lease violation, or subsequent to an eviction, they can be recovered in small claims. But in a time when the tenant may be disputing whether or not these charges are legitimate in the first place, we believe it would be unjust to evict them for not basically paying under duress something that they may or may not even be able to afford. given that the landlord could say, you owe me $5,000 in fees, you damaged the property, you owe me for my attorneys, and that potentially you could use the non-payment process as a weapon to enforce that even when it's still in dispute.
Okay, thank you. I just was formed by legal. That may be existing law anyway. All right, jump to section 5, number 4C. In this 5, you guys actually have a thing in here that allows the tenant to sue the landlord for damages. And then 4C says one of the determining factors for the judge is the degree of harm to the tenant caused by the landlord's conduct. Is there anything in here where that opportunity for the landlord's also allowed? Is there something in this that will allow, just change the wording, the degree of harm to the landlord caused by the tenant's conduct?
And I'll send this to Nick, but I believe this is Jonathan Norman, for the record, is in the current law. And if you think about, this is specifically when a landlord has withheld the ability of a tenant to get, if you look back at 3, so it's section 4, subsection 3, this is about, I believe, recovering property, retrieve his or her essential personal effects. So that can be things like essential medicine or tools if you're a contractor that needs specific tools for your job, your livelihood. And if the landlord blocks your ability to access that, then this is that mechanism. But generally, summary eviction is about possession, so generally it's not dealing with money, and the way that a landlord could recover money would be to initiate a small claims action.
Okay, but you guys this is after the summary eviction process has been completed. You're allowing the tenant to go back. By then, I would assume he would take his tools or medicines or something like that. I mean, the summary eviction process isn't like overnight. Even now, it's a week or so. So I'm kind of wondering, the way this, and our legal counsel whispered in my ear that some of this is already existing law. So I'm a little confused because normally when it's in blue, it's new law, but this is like repeating existing law. So I'm sorry if I'm reinventing the wheel here a little bit. But I don't know, as I look at it, it just seems so remarkably one-sided. And believe me, with Assemblyman Carter, I signed on to Senator Neal's bill about limiting the number of housing and rental units that these giant corporations are taking over. I agree. I think it's a huge problem. We should have dealt with it 2 years ago when we had almost the same bill. What the heck's going on there in that market? I don't know, but I'm highly suspicious. It's people with incredible sums of, frankly, trade dollars, the balance of trade. Those monies are coming back in our country, and they're using those things to buy up all the rental housing and make brand new housing tracts exclusively for renting. Very unusual circumstance. So I'm very sympathetic to that concept. On the other hand, there's the average landlord out there who has 3 rentals or whatever, and then you get some really sharp tenant who starts playing these legal time frame things, and it can be weeks, months before they can be evicted. In the meantime, they trash the place, and then he said, well, you can take them to small claims. Yeah, well, get blood from a turnip kind of a situation. Obviously, if they can't pay the rent, it's highly unlikely you're going to get a summary judgment or a judgment at all in a small claims action that you can legitimately collect on. So anyway, as I look at the whole bill, some of it, I don't want to see people who go on vacation or to another country and been gone for a couple of weeks and their check bounce, having all their possessions locked up and, treated like they're criminals because their check bounced or whatever. But on the other hand, I suspect that's rare. I think most of these situations are people that flat either, struggling or just simply gamble the money away. I mean, there's a lot of potential things that people do with monies other than pay their legitimate costs. And I don't think it's always fair to hold the landlord like he has no legitimate recourse to try to collect what was legitimately a contract between himself and a tenant. So with that, thank you, Madam Chair, for letting me ramble on a little bit. But, there's some elements of this that just seem exceptionally one-sided.
If I may, Jonathan Norman, for the record, I appreciate that. I think this bill boils down to, do you think it's fair to make someone sue themselves or lose their rights? And because that's the change. And I'm happy to swing by and we can walk through our little thing, showing you how little we're actually changing in this law. And if you think of any other area of law, imagine if you're walking in a grocery store and you have a slip and fall, and imagine the plaintiff's attorney just has to give notice to the store that they're being sued, and if they don't go file a pleading to start the case, the store, then they lose and they get damages against them. It's just, whether or not these cases, how they end up being adjudicated is almost irrelevant, because we believe in due process in our country. We believe that complaints come first. I mean, this is the only process, and the idea that it's one-sided, every other state in the country, every other jurisdiction follow, we are the outlier. We're the oddball out. And so, correcting that and saying, hey, if you want to sue somebody, you actually have to file a complaint, feels like a very normal, non-controversial thing to say. I mean, this is the second time we've brought this bill, so I've answered these questions twice, so I know it is controversial, but, it is, to me, just about kind of fundamental fairness. And I would never, so we have, I'll give you an example. We have a habitability bill working through Commerce and Labor, and I would never suggest that, when a tenant is facing a habitability issue, that they just post a notice on the landlord's door, and if the landlord doesn't respond, the tenant wins, right? Because as an attorney, I believe in the fundamental fairness that if you want to sue somebody, you need to sue them. You can't say, sue yourself or you lose. And I'll be happy to pick up that conversation
Well, Jonathan,
offline.
you and I have had many good discussions over the years, and I always enjoy those. So please come by. Just a little one-sided in all of this. So anyway, thank you, Madam Chair.
Max Carter for the record. Senator Hansen, I'd like to point out that the overwhelming majority of renters aren't going through a summary eviction process. This is a minority, and we're also dealing with, it's even changed since 2 years ago, where evictions on your record have been totally weaponized, just like credit ratings have been weaponized in the rental world. We've seen it come to light in the last 2 years that there's national databases. So if you get evicted in Las Vegas, you try to start your life new in Alabama, good luck finding a rental if you've got an eviction on your record. There's been too much weaponization of this, and we need to, that's what this is about, is making sure that something that is being overly weaponized only happens when it should. That there's due process.
Well, Assemblyman, I appreciate that, but I would say on the other hand that if you came to rent my property and I had no record of your past history, and then I find out you have, out of the last 12 months, dodged out on paying 6 months worth of rent, I would love to get that information. And ultimately, whenever we have a situation where somebody doesn't pay the rent, somebody else down the road is going to get stuck with that bill. Because you pass the costs on, and that's why rents also go up when you're in areas where people aren't paying their bills and slipping out, because somebody's got to make up the difference. The payments still have to be made, the insurance is still to be paid. So yeah, and while I don't like the weaponization, I don't know if that's the right word, just like when I have employees that I have come to my plumbing company, and I do a background check on them, and I find out that they've had some serious issues with the law. They don't get a clean start, right? Because they could impact my customers who I'm sending into those homes. Ditto for renting. If I'm going to have I have one rental, my grandparents' old house. And I'm very careful who I put in there because I've had several situations where being a nice guy cost me 6 months worth of rent. So anyway, thank you, Madam Chair.
Thank you. Other questions? Let me go to Senator Orenshaw next, and then we'll come back.
Thank you very much for your indulgence, Chair Scheibel. And I know Assemblymember Carter and I, we both grew up in Southern Nevada, and I think, it's shocking and heartbreaking to see how many unhoused are on our streets now. And I'm just wondering if you think the changes in Assembly Bill 283 might help tenants who are on the edge of becoming homeless be able to get caught up, get the rent paid, and try to not fall through that net and now join the ranks of these growing ranks of our unhoused Southern Nevada, Northern Nevada, all over the state. Whoever would like to take that, thank you.
Thank you, Senator Orenshaw. Jonathan Norman for the record. I can't think of our homeless population without thinking about evictions because I think it's a direct pipeline. And what I would say is, The earlier our social services agencies can get upstream on these cases, the better. So when a tenant is at risk for eviction, for example, I think outcomes are changed if the court has more time to work, and that could be in the context of rental assistance. Las Vegas Justice Court has a pilot rental assistance or eviction diversion program, and it's limited to, I think, seniors and adults with disabilities. And so they're able to route the eviction case from we have the form answers on our website, and so a person can check their age or that they have a disability, and it gets routed to a court where we're assessing for rental assistance. We're also assessing for sustainability of that home. So if it's somebody on a fixed income and rent, and Clark County has gone up 40%, I think, in the last 5 years, and that's not sustainable, then that group starts pivoting to where can we rehouse this senior where they're safe and stable. And that also, legal aid has advocates who review those cases, and if there's a legitimate defense, we'll step in and represent that person, but also just helping them navigate to a sustainable home. Having the complaint come with the official court stamp from the court lets tenants know that this is something serious. And I'll just give you an example why that matters, having the court stamp on there. There are some multifamily units that paper every unit with a non-payment of rent on the first of the month. So people are habituated to not understanding that this is serious. And I think having something from the court that says, go to the Civil Law Self-Help Center at Las Vegas Justice Court and make sure you file an answer within 7 judicial days is really important versus something your landlord just posted that doesn't have, a court stamp on it. And so, yeah, I think it is definitely, we can't deal with our homeless crisis if we don't deal with evictions and with housing. So thank you for the question.
Thank you, Mr. Norman.
Max Carter for the record. And I'd like to say that the core of what you asked ties into what we were having the discussion with momentarily before. This bill is not about protecting bad actors. This bill's about making sure that those that end up on those lists with that eviction on their record has been done appropriately, that we're not putting people on there. If bad actors, they deserve it. This is just making the process to where we make sure that it's the bad actors that are on those lists, not unfortunate people that have run into an unfortunate circumstance.
Thank you, Assemblymember Carter. Thank you, Mr. Norman. Thank you, Chair Scheibel. I appreciate the bill, and I think anything we can do to try to, stop the ranks of our unhoused brothers and sisters getting bigger would help. Thank you.
All right. I think Senator Ellison, you had another question. Go ahead.
Yes, ma'am. I see this every day, and it's got to the point where it's become a scam. I've had senior citizens come to my office just recently. They've tried for 4 months, tried to get these people out. They rented this house to a man and a woman. Well, apparently she had 4 kids, and they ended up moving in with them, which the landlord didn't know. So she went over there, and you should see this house. It's destroyed. So they filed for an eviction. You're talking going on almost the third month to trying to get the rent and get them out of there. Next thing you know, guess what? There's not a window left in that house. Period. It's a beautiful old house. They busted every window out of that house. Then she goes in the backyard. They finally let a policeman walk them into the backyard to see what kind of damage is back there. And they were getting subsidy food. They never ate it. They just take it into the backyard and pile it up. And it was piled up massively. So by the time they finally got them out of there, it took 4 months. And I hear this all the time. And these people are paying the water, the sewer, and garbage. They're also paying house payment. And you think it's easy on the landlords? It's crazy. It's become a rentals paradise for people that don't want to pay. And that's what it's come to. And you're going to see more and more and more landlords are going to put these places up for sale because of this kind of problem. You can't get people out once you get them in. And I don't care what you say. I see it all the time. And you get an eviction, good luck. You might be months trying to get them out of there. And by then, the bills are so massive, then when you try to go find out if you can go after a small claim, that's another disaster. That don't happen. They've got to come up with some kind of situation and make it work. And are they on the street? No, by then they'll have another place to rent. So they got to have some kind of notice that, hey, this is a common thing with some of these people. John Carpenter, state assemblyman, was here for years. When COVID hits, they almost lost everything they owned on a trailer park. It's a big casino next door. They all worked at the mines making $100,000 a year. They were getting money from subsidies, and they are going to the casinos every night and not paying one drop of rental payments. So they almost lost everything because of that trailer park. So I see the other side. If somebody comes to me and says, hey, I can't pay my rent for 2 weeks, fine. I don't have a problem with that. We'll work it out. But the next month you'll say the same thing. The next month, the same thing. But I feel sorry for the people with children. But I tell you what, it's got to the point where it's not. This has become a problem where you can't, once you get them in there, you can't get them out. And then you get a sheriff, and you have to get a sheriff, go to the court, get the sheriff, go post the door. That's another 7 days. And then and I don't have this problem. But I tell you what, the older people is the ones that are getting scammed. And this woman worked at the hospital till she was 80, and they can't afford it. They've got major problems. So I feel sorry for these seniors that own property. I tell them, I said, if I was you, I'd put these places up for sale and let somebody buy them as a house, and to heck with the rentals. That's what I do. And that's what's happening today. People are going to start putting these places up for sale, and then there'll be no rentals. That's what's going to happen. And it's mostly the seniors that are getting scammed. I hate to say that, but it's the truth. Thank you.
Thank you, Senator. I appreciate the sentiment. I can't speak to those specific cases, but I will say that, as far as mobile home park, it's not governed by this chapter. That's a different chapter.
1B. I know the law. Yeah.
So we're not changing that. And then I would also just say that I don't know that we advertise this, but legal aids for seniors who have terrible tenants in their home, Legal Aid Center and Civil Law Self-Help Center on our website has all the forms and the tutorials for landlords to properly do an eviction and make sure that they stay on track. I've had legislators call me asking me questions about an eviction form that they can't find because they're a landlord and they have a problem tenant, and we have all those forms. We have really developed things for people to follow along to make sure that they do the steps in the eviction right. I think, our legal process, whether it's for landlords or tenants, is very confusing often. And, if there's an opportunity in a future session to work through whether it's 118, A or B, or Chapter 40 to make it more accessible to, because I'm assuming those folks were representing themselves, right? They don't have an attorney. And they should be able to read the law and know what they need to do and not get lost in a maze where it takes 3 months, because if you follow the eviction process, there's no eviction in this state that should take 3 months. So I appreciate the sentiment. Okay.
All right. Of course. Any further questions from members of the committee? All right, I'm not seeing any more questions. Thank you so much for your presentation this afternoon. We will move now to testimony. I will start with in-person testimony here in Carson City and in Las Vegas. Just looking at the clock, I know that we do have committees that start at 3:30. I'm not going to cut you all off at 3:30, but we're going to start with testimony in support, and depending on how things go, I may give you a little warning to wrap it up, but everybody is entitled to 2 minutes to give their testimony. I encourage you to say, come on down if you're going to testify. I encourage you to say ditto, I agree, same Z's, if someone else has already mentioned the same reasons that you were going to give for your support or opposition. Again, we will start with in-person support. We will start in Carson City, then we will go to Las Vegas, then we will go to the phones, and we will do an assessment then of how close we are to getting everybody on the record. So please go ahead.
Cool. Thank you, Chair Scheibel. My name is Ben Innes. That is BENINESS. I am the coalition manager for the Nevada Housing Justice Alliance. We are a statewide coalition of grassroots organizers, community advocates. We fight with tenants across the state for meaningful tenant protections and housing stability. I'll ask that all of our supporting partners keep their remarks short today. So we believe in order to address our state's housing crisis, that includes establishing a long-term foundation for a tenant bill of rights for folks in Nevada. This includes starting with eviction reform. I think for the case of eviction reform, that's not a foundation. It's kind of filling in the gap. There's this deficit. We're not starting at zero. We're in the negative with how the system works. With our high cost of living and historically high rents, 60% of Nevadans are cost burdened. This was put out last year by UNLV's Lead Center. So that means each and every month they're precariously juggling high rents, other essentials, or risk facing becoming unhoused and displaced. We're the only state to use this process. I wish that was like the only sufficient argument to put this to bed. And Nevada has some of the highest eviction rates in the country, particularly in Las Vegas, which was highlighted. And this means that thousands of Nevadans have to navigate an unclear and unjust process while trying to remain stably housed. This conversation isn't about good or bad tenants, and it's not about good or bad landlords. Again, it's, I think, about due process, a clear system, a fair system, and we believe it's time for Nevada to match that national standard, and again, give tenants that due process they deserve. And I'll leave it at that. Thank you so much. And again, thank you for hearing the bill today.
Hi, guys. Madam and Chair, thank you. My name is Madison Proctor, MADDISON. I'm here on behalf of the Nevada Women's Lobby in support of AB 283. Just to keep it short, we are dittoing, and this bill improves fairness in the eviction process rather than placing the burden on the tenant to respond before any case is officially filed. This promotes due process and a greater equality in housing. We urge your support. Thanks.
Good afternoon, Chair and members of the committee. For the record, my name is Tara Webster, TARAWEBSTER. I'm the policy manager with the Progressive Leadership Alliance of Nevada here in support of AB 283. This bill is a crucial step forward in tenant protections in our state, promoting long-term stability and safeguarding tenants from unfair eviction. These protections are especially vital for those who are higher risk of losing their housing, including low-income households, seniors, and children. Every year, over 80,000 Nevadans face eviction, and these evictions have negative cascading impacts on families. I really want to focus on children because they aren't just losing a home, but their educational opportunities. Children facing eviction and relocation outside of their district experience reduced funding and access to resources, increased poverty, poor academic performance, higher rates of absenteeism, and more frequent suspensions. Housing instability and summary eviction are not solely the result of individual financial irresponsibility or poor tenant behavior. Sometimes families are just struggling. Rather, these problems are systematic and stemming from discriminatory practices and policies. These issues place all renters at risk of eviction and create significant challenges in navigating the summary eviction process. The Progressive Leadership Alliance of Nevada views Assembly Bill 283 as a common sense bill that will make Nevada's eviction process more equitable and more in line with how the majority of other states operate. With that, we urge your support.
Good afternoon, Chair and members of the committee. My name is Serena Evans. I'm the Policy Director for the Nevada Coalition to End Domestic and Sexual Violence. NCE-DSV is a proud member of the Nevada Housing Justice Alliance, as housing access and tenant rights are proven violence intervention and prevention measures. When folks are unhoused or experiencing evictions, they are at increased risk for violence, and it also plays, it's cyclical in the cycle of violence. So this is a victim-centered prevention effort, and we support this bill. Thank you.
Hello, my name is Aisha Goins, AESHAGOINS, and I am here on behalf of SEIU 1107 and their 20,000 members. This bill is consistently concerning, especially since we are the only state that doesn't offer due process. Our members come from all over, and the laws are different all over. And oftentimes we find ourselves in situations where they just didn't understand the law. Something was posted on their door and they moved. And this just happens all the time. So on behalf of our 20,000 members, we ask you to consider this bill. Thank you.
Good afternoon. My name is Tia Smith, TIA-SMITH. I'm a policy attorney with ACLU of Nevada. ACLU of Nevada is part of the Nevada Housing Justice Alliance. We are so appreciative to Assemblymember Carter for bringing this bill and sponsoring it, championing summary eviction reform. We very much support this bill, and we hope the committee will as well. Thank you.
Hi, my name is Emmy Miranda. That is EMYMIRANDA. Thank you, Chair and members of the committee, for being here to hear this out. I am the Housing Justice Organizer with Make the Road Nevada, alongside with Nevada Housing Justice Alliance. I am here in support of AB 283, which corrects Nevada's unusual and harmful summary eviction process. This bill would reverse that and ensuring tenants get a fair and just due process. Please support AB 283. Thank you for your time.
Good afternoon, Chair Shriver and members of Senate Judiciary. My name is Jungmin Lee, JOUNGMIN. I deal with what others said. Thank you.
Hello, good afternoon. My name is Nixie Sosa, NIXIE, SOSA. I'm with Make the Road Nevada, a member of the Housing Committee. I'm just here to ditto. Thank you.
Good afternoon. Thank you for having me here. My name is Hallery Ferrini, HALLERY FERRINI. I'm also here with Make the Road Nevada. But pretty much we just want you to urge to support AB 283 because all Nevadans deserve to have a chance for an eviction hearing. Tenants should have access to resources and interventions when coming to court and should have adequate time to find new housing. By reversing this filing order, tenants can ensure they are afforded a basic level of due process in the eviction process. Thank you.
Okay, we will go to Las Vegas now in person testimony. Please go ahead.
Hi, good afternoon. My name is Lorraine Oliver, spelled LORRAINE, last OLIVER. I am a proud retiree member of SEIU. I would like to say that my career involved maternal child health for the most of it. And it was the kind of thing that was very hard to see when mothers and babies and older people were being evicted really fast from place to place, very disorienting, unable to secure a place and a way forward for their lives. I agree with Senator Ellison in his comments, but it is such that a lot of people are indeed struggling. I urge full support for AB 283 as it relates to tenants. Thank you.
Hello, my name is Jahaira Remendez, YAJAIRA She, her, my pronouns. I'm a proud member leader from Make the Road Nevada. I can fully support AB 283, summary eviction presented by Senator Carter. This bill reverses the summary eviction process for tenants in the non-commercial properties, requiring the landlord to file first with the courts when requesting an eviction order. For tenants, this will make it clear, fair, while having the court process in this impact story of my eviction. I live in a former residence of 2 years. In November 26, 2023, I received an eviction letter saying I only had 48 hours to move due to the former landlord had been running an illegal RV encampment and she had 8 RVs parked on the property. She was fined by the city as well as zoning issues and residential. I am struggling with cancer as well financially. I moved in and I packed up my RV, and also in a residential area, I found a new parking spot. Due to that, I also didn't have any food or as well skyrocketing medical bills, and I was either paying for rent or food. Right now, Make the Road Nevada organization has given me my resources and helped me and be able to have a new home, RV home. I now say that I have a stable, safe, and secure place to call home in a living environment. This is my eviction story. Thank you.
Good afternoon, Chair and members of the committee. My name is Diana Diaz. That's Diana Diaz. I'm a resident of Las Vegas, Nevada, a senior citizen and a proud leader with plan. I'm here to express my strong support for AB 283. I believe this bill should be passed by this committee because it's designed to benefit the people, not just landlords. America was built for the people, not solely for business interests. I have personally experienced eviction 7 times in the past. Every time I did my best to pay my rent and keep a roof over my head. It's not fair to tenants are expected to bear all the burden. If the landlord wants to remove someone from their home, they should be the ones responsible for filing the proper paperwork, not the tenant. There are far too many people unhoused in Las Vegas, in Reno, and across the United States. We need to do better. I urge you to support this bill and take a step towards reducing homelessness and fixing our broken housing system. Please help us, help the people. Thank you. Pass AB 283.
Good afternoon. My name is Michelle Van Collins, and I'm a proud member of Make the Road Nevada and a housing representative of the same organization as well. I've lived in an apartment for over 5 years in Las Vegas, Nevada. And when I started to notice mold problems, I immediately contacted the landlord to make repairs, but the request for the repairs never took place. When they finally did respond, they told me I had to vacate the apartment and find another place to stay, with a promise to reimburse me later on. Being that this property is a government-assisted property that has certain rules and regulations, me moving to another unit or just moving out, that would be a violation of federal law, local city law as well. And I wasn't going to risk my record criminally or my ability to rent based on their manipulation of their tenant type of rules for me to find some place to live. So when I didn't have the funds to move, they reiterated for me to try to move to another apartment, which I was confirmed by going to another government agency that would be illegal. So I came home one day and I noticed an eviction notice on the door. Without me having time to prepare for the case, I went to the court, and it was barely a minute before a summary eviction was, granted or judged against me. It's important that this bill is passed because there needs to be a stop to the bullying and the manipulation of eviction laws towards tenants such as myself when it was merely an issue of making repairs due to their neglect of handling their property. I do reiterate that I am in support of this bill. Have a great day, and thank you for the opportunity for me to share my story with you.
Good afternoon. My name is Tysacan Hall, Taisacanhall. I'm a housing justice advocate and a renter here in Las Vegas. I'm testifying in support of AB 283 because this bill is not just about improving legal procedures. It's about protecting the rights, dignity, and stability of our most vulnerable residents. The current system forces tenants to navigate a confusing, unfair, and disorienting system during a time that is undoubtedly already stressful. In 2018, I experienced the devastating effects of this system firsthand when I was evicted with my mother and my 2-year-old brother at 8 a.m. We were told there was an eviction notice on the door, even though we were certain there was not. We were given 30 minutes to gather our belongings, and without a car, it was impossible to carry everything we needed. The emotional toll of that day was immeasurable, and we lost precious memories, personal belongings, and some of our vital documents. This began a cycle of instability, bouncing from one temporary situation to another, and it would be 2 years before I would have a place to call home again. This is one story of the thousands of Nevadans that face similar circumstances on a daily basis. As we face an ongoing housing crisis in Nevada, AB 283 represents a much-needed step toward creating a fairer and more just eviction process. I urge this committee to vote in favor of AB 283 and take meaningful steps to reform a system that has left too many Nevadans struggling to survive. Thank you.
Good afternoon. My name is Sean Best, SHAWN-BEST. I work as a cook on the Las Vegas Strip, and I'm a culinary union member. I was evicted in September of 2020 from a place called Westland Real Estate, which is one of the many corporate owned apartment complexes. After they served a 5-day notice for a summary eviction. When I got that eviction notice on my door, I felt frightened. It was during the COVID-19 pandemic. So while I was working full time, there was a lot of uncertainty from closures and no hope of a vaccine at that time. I worked with lawyers to file a motion to stay and a motion to set aside. Both were denied by David Brown, who was the hearing master, about 2 days after I filed them. I felt like he didn't even look at my motions and just rubber stamped the eviction. I was evicted in September 2020 when there was an eviction moratorium. When I got the 24-hour notice from the constable, I moved as much of my stuff as I could in my car, started living in hotels, and then I contacted Attorney General Aaron Ford's office to help. After a week after I was evicted, I got a call and an email from the landlord. They said they confirmed with their corporate that they made a mistake in evicting me. They said I could move back to the same unit and that I could pick up the keys since they had changed the locks already. No apology, but I'm really thankful that I had the help from AG Ford's office. It really helped me during a difficult time. This was the first time I was evicted, so I felt scared going through the process. I didn't know where I was gonna go or what I was gonna do with my stuff. I was scared of becoming homeless or having to live in my car. I'm a diabetic, so I was especially worried about how I was gonna be able to store my insulin. Remember, in September, there was no vaccine access yet, so it was pretty stressful. Going through the summary eviction process myself, it felt like there was no compassion at all. I felt like landlords have the upper hand and they just want you out. And if they do, that's what happens. I'm sharing my story today to encourage the Nevada legislature to please end summary evictions. Thank you.
Good morning. My name is Minister Drake Macon with Wealthy Place Ministries. I'm here with Faith in Action, Nevada. Here in support of AB 283. Ditto to everything that's been said, but I'd like to also add a circumstance with my mother, who had been a good paying tenant for years with her apartment, but because her units were sold to a new company, immediately got a notice to move out. The rent went up $500 instantly, and they gave her less than 30 days to get out. So she called me and we had to gather her things and also try to find her somewhere else to live. So I think we just need a little bit more fairness, with this change in this law, so that people will have time to have recourse to take care of their business properly. Thank you.
Hi, good afternoon, Chair Scheibel and committee members. My name is Brian Harris, that is BrianHarris, and I'm here in support of AB 283. I'd like to ditto the comments made before me, and I would urge you all to please support this bill. Thank you.
Hi, my name is Isabel Pastrana, Pastrana. I'm here for Make the Road Nevada. I support AB 283. Thank you.
Good afternoon, Chair and Committee. My name is Shonda Johnson, SHAUNDA, JOHNSON. I'm here with Faith in Action Nevada as an organization that works with faith communities to build a more just and equitable Nevada. I feel compelled to speak in support of AB 283. I ditto the sentiments that have been shared already, but especially because summary evictions have a ripple effect, not just on individuals, but on society as a whole. And has been said, housing instability is a major contributor to student truancy and absence, lack of healthcare, job loss, community connectivity, and homelessness. And I think it's really important that as policymakers, your policies are just and fair for all. I think that landlords, being a landlord is a privilege, not a right. And we need to make sure that it's a balanced process for our communities to all be made whole. Thank you.
Hi, good afternoon. My name is Alejandro Ramos, and I support AB 283. Thank you.
All right, at this time, we will move to testimony in support of AB 283 on the phones.
Thank you. If you would like to offer testimony in support of AB 283, please press star 9 to take your place in the queue.
Good afternoon, Chair Scheibel and committee members. For the record, my name is Matilda Miller. That's Mathilda Miller, Government Relations Director of Native Voters Alliance Nevada, and we're in strong, unwavering support of Assembly Bill 283. We're also proud members of the Nevada Housing Justice Alliance. Last summer, while court watching with the coalition, I witnessed 262 families lose their homes. I watched mothers cry while standing there with their children. I saw elders beg for more time. I witnessed working people try to explain how they missed the deadline that they didn't even understand. That's 262 families. They were gone in minutes, sometimes even seconds, without ever really being heard. And they were told, "I wish you the best," before the court moved on to the next name on the list. And that's why we're urging the committee to support this measure, because no one should lose their home without a chance to be seen, to be heard, and to be treated with dignity and due process. Thank you.
Hello, my name is Carissa Pierce, CARISSAPEARCE, and I am representing the Children's Advocacy Alliance. And I just want to emphasize that the current summary eviction system in Nevada is extremely punitive because it places the burden on tenants to initiate the legal proceedings against themselves. And that's something that no other civil process in our state requires. So for families with children, this means that they are being forced out of their homes, likely without ever stepping into a courtroom. And because of that, we're seeing some severe consequences, where in 2023, nearly 30,000 children in Clark County were identified as experiencing homelessness or housing instability. And of those, approximately 7,000 young children between the ages of 0 and 3 were experiencing homelessness and not connected to any age-appropriate support services. So AB 283 is essential because it ensures that families have the opportunity for a hearing, for due process before they lose their homes. Thank you so much for the opportunity to provide testimony. We are in strong support of AB 283.
Hello, thank you for having me here today. My name is Isaiah Gallegos. My name is spelled ISAIASGALLEGOS. I'm a resident of Las Vegas, and I'm here in support of AB 283. And I ditto all that I said previously before. Our eviction system needs reformation and needs protections for tenants. Thank you. That'll be all.
Good afternoon, Madam Chair and members of the committee. My name is Brittany Kemp. For the record, that's BRITTANYKEMP. I am the state organizing manager for Make It Work Nevada, a reproductive justice policy organization. At Make It Work Nevada, we place housing as a reproductive issue as it affects the quality of life for individuals and their families. We believe Nevada renters deserve not only safe and stable housing, but also fair eviction proceedings if they are faced with that harsh reality. AB 283 would strengthen tenants' rights, giving them a better chance at due process in the face of an eviction. We urge the committee today to support AB 283 and this critical piece of legislation or reform. I thank you for your time.
Caller with the last 3 digits, 355. You are unmuted and may begin.
Hello, my name is Kristen Aviles.
KRISTINAVILES. I am here on behalf of HopeLink of Southern Nevada. HopeLink provides rental assistance to tenants facing immediate risk of eviction. We support AB 283 as it grants us additional time to collaborate with landlords and tenants to assess rental assistance needs effectively. This extended timeframe ensures that qualifying landlords receive the back rent owed to them while preventing further homelessness in our community. When evictions are expedited, both landlords and tenants may lose access to critical financial assistance that could benefit both parties. Thank you.
If you have just joined us and would like to testify in support of AB 283, please press star 9 to take your place in the queue. There are no other callers wishing to offer support testimony at this time.
Thank you so much. We will now move to opposition testimony on AB 283. We will start here in person in Carson City.
Good afternoon, Chair Scheibel, members of the committee. It's an honor to be before you today. My name is John Sandy, here today on behalf of the Nevada State Apartment Association. Before getting into it, my clients did ask me to recognize, that evictions, whether they're summary or formal, are very stressful times. It's a very human experience, and it's not something that is lost on landlords. It's a stressful and a difficult process for them as well. With that, I'd like to begin by taking a step back and discussing how Nevada's existing summary eviction law process works. In Nevada, there is a summary procedure, as we've heard a lot about. There's also a formal eviction procedure. A formal eviction follows much the same process we discussed. A landlord will file a complaint, which will be answered by the tenant. And there's a distinction between those two. In a summary case, the only dispute is the return of the property to the landlord. They're not filing for money damages like most civil cases are. In actuality, most civil cases, you have to have a threshold to even have jurisdiction within a case. That's not the same type of procedure that is followed in an eviction proceeding, because these are naturally different types of processes. Because the inquiry is limited to monetary damages, the law does not require landlords to initiate a full lawsuit at the outset. Instead, the process is designed to be simple, efficient, and accessible for both parties without the need for expensive legal representation. In fact, landlords and tenants often resolve rent disputes without any court intervention because of the system and the way that it works. Under the current law, if a tenant fails to pay rent, a landlord must file a 7-day notice to pay or quit. This notice informs the tenant that they must either pay the outstanding rent or vacate the premise within 7 judicial days. Or if they believe they have a defense, that they've rightfully withheld the rent for a purpose, they may file an answer with the court to trigger the summary eviction process, where they would have the due process to go before a judge and adjudicate that claim that they have a legal defense. Now, if the tenant does file this answer, the court schedules a hearing, and depending on the court's efficiency, that hearing may occur within a few weeks, although at times, especially in high volume instances, it may take much, much longer, often several months. At the hearing, the tenant has the full opportunity to present any defenses. If the court finds a valid defense, the eviction will be denied. If not, the court authorizes the constable to perform the lockout. Now, let's compare this existing process with the changes that are proposed under 283. AB 283 would require the landlord, after posting the initial notice, to make an additional step, filing a formal complaint with the court. Now, this adds another mandatory waiting period of at least 7 more judicial days, which in real-world terms means about 10 to 13 calendar days. So after you include service of process and everything, you're probably well over 2 weeks. And I did want to mention something about service of process. The gentleman who was testifying from Las Vegas did say, in fact, correctly point out that the initial notice is posted on the door and mailed to the tenant to ensure that they get it. The way I read it, that's also the same for the summons and complaint, but they did reference that the summons and complaint would be done by a process server. Now, the big concern about that, obviously, is it adds a lot of time and expense to the process, but if somebody knows that a process server is coming, they know they didn't pay rent, they know that the notice has been posted, it's much more easy to evade that notice. And under this bill, if the landlord doesn't serve them within 15 days, delays, the eviction goes away and they have to refile. So if you have, I think there's been talked, if somebody's very shrewd and knows the laws and knows how to do it, they avoid service and they could perpetually stay in that property for a long time. Now, I'm not sure that's exactly what this bill says, but I did want to put that on the record in case my reading of that was incorrect. So in essence, anyways, under AB 283, we're adding quite substantial time and cost to a landlord to go through a process that already does take quite a bit of time and already does cost quite a bit of money. So in theory, the benefit to the tenant under this bill will be that second notice. In reality, the tenant has already received the notice through that original posting, so this new filing requirement simply just adds delay. It does not create new rights for the tenant or materially enhance their opportunity to assert defenses that they already have today. Meanwhile, the burden of this delay falls heavily on the landlords, especially small landlords who rely on rental income to meet mortgage payments, maintain properties, and keep housing available. More importantly, these additional burdens will inevitably be passed on to tenants in the form of higher rents and reduced housing supply. Now, it's critical to understand that this streamlined eviction process benefits tenants to both existing tenants and increases our housing supply. But to conclude, I did want to mention that the eviction process itself does not cause evictions. The real drivers are the broader economic pressures, especially the rising costs of housing. Adopting policies that increase costs and administrative burdens on housing providers will only worsen those pressures, leading to even more instability for renters across our state. We understand and support the goal of ensuring tenants are treated fairly, but AB 283 is not the answer. It introduces new costs and delays without providing any meaningful new protections, and it undermines the process that already is balanced and accessible. So for those reasons, we urge the committee to reject AB 283. If there are any questions, I'd be happy to stand for them, but thank you for your time.
Good afternoon, Chair Scheibel and members of the committee. For the record, my name is Taylor Avery, and I'm the Manager of Political Affairs for the Vegas Chamber. The Chamber is in opposition of AB 283. Although we appreciate efforts to reform the summary eviction process, this bill will make the process more confusing and burdensome on both tenants and landlords. The bill requires landlords to file at the court regardless of whether the tenant plans to contest the eviction, which could burden the court system with unnecessary filings. The bill also lengthens the summary evictions process, putting small landlords on the hook for months of lost income and limiting their ability to curb potentially dangerous behavior in a timely manner. The Chamber supports modernizing the eviction process in a way that does not impose unnecessary burdens on businesses and property owners, which we feel that this bill doesn't do. Thank you.
Good afternoon, Chair Scheibel and members of the committee. For the record, I'm Mindy Elliott with Flynn Judiciary Government Affairs, and today I'm speaking on behalf of the Nevada Public Housing Authorities, Southern, Reno, as well as rural housing authorities. And these are the largest landlords in Nevada. I'd like to thank Mr. Norman and his team for allowing the housing authorities the opportunity to explain our concerns. You saw there was an amendment that he shared with you today that has been dismissed by the housing authorities in the previous House. While we appreciate the intent of AB 283, we respectfully request that the three housing authorities be exempt from this bill. PHAs are already governed by federal law, and HUD already requires a 30-day notice before eviction of non-payment of rent. These protections are codified in federal regulation and include structured repayment plans, as well as due process through grievance procedures. We also have uploaded a letter signed by all three entities to Nellis for your reference. AB 283 would require PHAs to implement parallel processes, creating costly and conflicting requirements with no added benefits to the tenants. Existing federal law already provides strong protections while ensuring program accountability. For these reasons, unless amended to exempt PHAs, we must oppose AB 283. And just for a reference, we are not PHAs are exempt from other states as far as eviction processes are concerned. Thank you so much. Appreciate your time.
Thank you for your testimony. I don't see anybody else coming forward in Carson City, so we'll go to in-person opposition testimony in Las Vegas on AB 283.
Cyrus Hojati, CYRUS HOJJATY. I'll speak in opposition. I'll ditto the comments. Thank you.
Chair Scheibel and members of the Senate Judiciary Committee. Good afternoon. My name is Melissa Saragosa Stratton. I am legal counsel and here today on behalf of the Nevada Realtors. I'm also very familiar with the summary eviction process, having recently retired from the Las Vegas Justice Court, where I served as a justice of the peace for 18 years. As stated, they handle about 75% of the state's summary evictions. The Nevada Realtors are opposed to AB 283, and I would echo the comments of those before me and try to steer towards separate areas. The Realtors do desire a fair and balanced summary eviction process. We understand that the current summary eviction process may not be perfect, but it has been in place for nearly 40 years. The Landlord-Tenant Act was adopted in 1985. Turning this system on its head is more likely to add to the confusion rather than it is to aid in a party's understanding of the process, even if we are an outlier at this point. While I was with the Las Vegas Justice Court, I was actually the person who wrote and presented and was awarded the grant for the eviction diversion program that the Las Vegas Justice Court has in place. And at this point, it currently boasts a zero recidivism for future evictions for those who go through the process successfully with the current procedure in place. Due process requires notice and an opportunity to be heard. That exists in the current statutory scheme. The notice is given to the tenant. They have the opportunity to provide what's been referred to as an answer, but in current statute, it's actually referred to as an affidavit contesting the notice to pay. It's not filing a complaint against themselves. It is opposing the notice that was served. We fail to see how lengthening the process with more legal paperwork and significantly increasing the burden on the courts and the landlords with more document filings, more procedural requirements, and a proposal that would impose tracking of those cases upon the court would be an improvement upon the existing framework. We've heard many today say they didn't understand. A tenant who fails to heed the notices currently provided. Those notices, by the way, are prepared in conjunction with the Las Vegas Justice Court and Legal Aid of Southern Nevada, who is in contract with the courts to operate the Civil Law Self-Help Center. Those notices are drafted by, in conjunction with them. They are very clear. And a tenant who doesn't read them and doesn't heed the notice and telling them what to do is in no more likely going to heed an unfamiliar language of a civil summons. Also, this bill goes well beyond the non-payment of rent scenario. We've heard a lot of comments today about the non-payment of rent. But this bill extends that same process and gives now the notice period and then again the complaint waiting period for all other types of evictions. A tenant who violates the lease or a statutory provision in a manner that causes a legal or safety issue should be addressed in an expedited, timely manner. For example, drug-related offenses, operating illegal businesses, subleasing property where it's not authorized by the landlord, committing waste, nuisance, holdover tenants who have no right to remain, or tenants at will. All of these evictions are wrapped into this bill and it extends the current timeline. What this bill does is actually remove and eliminate the entire summary eviction process. It doesn't just modify it a little bit, it completely removes it. It turns it into a formal civil proceeding. We firmly believe that any legislation should better a process, especially one that has worked since it was implemented 40 years ago. The three largest Southern Nevada Justice Courts successfully process about 5,000 evictions a month. It does nothing to better the known system in place. And despite what several individuals stated, it does not give every tenant a hearing. The current system only presents a hearing or offers a hearing when the tenant files an affidavit contesting the notice. The same is true of this construct. Even if this was adopted, every tenant would not get a hearing. Only those that heed the summons and file an answer with the court would be afforded a hearing. Just like any other civil action, there are default proceedings when the respondent doesn't respond. Landlords who routinely work with tenants to get caught up in rent when payments are missed will likely be discouraged from working with the tenant to find a solution or an opportunity to get caught up, because the longer process will leave them with not just 1 month of delinquent rent, but now multiple months of delinquency and no legal recourse to collect that delinquency without raising security deposits. A summary eviction is only about possession. I had one other comment I just wanted to make with respect to Senator Hansen's comment or question earlier about the service of the notice. About 3 legislative sessions ago-ish, maybe 4, NRS 40.280 was amended. It used to be that any agent of a landlord, to include any property manager, could serve a notice. That notice could be served, 1, by personally serving it to the tenant in the presence of a witness who would sign. 2, to the tenant, to a person of suitable age and discretion who was home if the tenant was not home, and also mailed on top of that. Or if no one was there, it could be posted and mailed. That construct still exists, but what changed several years ago was that an agent of a landlord may not serve anymore. It must be served by a constable or a licensed process server in this state, or of an agent who works for an attorney who's representing the landlord. So that is the notice procedure that's in place today. I'm happy to answer any questions. Thank you for your time.
All right, I don't see any questions here. Thank you so much for your testimony. And I don't see anybody else coming forward to give opposition testimony in person in Las Vegas on AB 283. So we will go to the phones for opposition testimony.
Thank you. If you would like to provide opposition testimony for AB 283, please press star 9 to take your place in the queue.
Good afternoon, Chair and members of the committee. I'm Kimberly Fergus, FERGUS. I rise in strong opposition of AB 283. This bill continues the dangerous trend we saw during COVID, handing all the power to the tenants while stripping landlords of basic property rights. During the pandemic, landlords were forced to house people for free. No rent, no relief, and no recourse. Many small property owners never recovered. AB 283 revives that same failed model, just repackaged. This bill makes it harder, longer, and more expensive to remove tenants who refuse to pay rent. It requires landlords to jump through more legal hoops, delay justice, and excessive notice periods, and encourages abuse of the system. Meanwhile, responsible landlords must still pay mortgage, insurance, property taxes on units that they can't even access. Let's be clear, eviction is not punishment. It's a remedy for a breach of contract. I'm going to say it again. Eviction is not punishment. It's a remedy for a breach of contract. But AB 283 treats landlords like villains for enforcing leases. There is no different than soft on crime, where criminals are out before the ink dries. Here, non-paying tenants stay while owners foot the bill. This bill invites freeloading, discourages investments, and kills affordable housing. Vote no on AB 283. And I would like to thank Senator Hansen and Ellis. I echo everything that they were asking questions and making statements. Thank you. Have a great day. Bye-bye.
There are no other callers to provide opposition testimony at this time.
All right, then we will move to neutral testimony on AB 283. Anybody wishing to give neutral testimony in person is invited forward to do so now. I don't see anybody coming forward, so we'll go to the phones for neutral testimony on AB 283.
If you would like to provide neutral testimony for AB 283, please press star 9 to take your place in the queue.
Good day, Chair Seibel and members of the committee. This is Dora Martinez with the Nevada Disability Action Coalition. I am in neutral. We are coalition people with disabilities, and we know that when we sign that contract to stay in a apartment or a home, that we need to, it's our responsibility to pay rent. The only thing that I hope that Assemblymember Carter will put in that bill is accommodations. We all know how the Department of Justice is being with the ADA, and it's a battle just trying to get equitable and accommodations for people who are deaf, who use ASL, or blind, which we prefer electronic and accessible lease agreement. So I hope that that's included in the bill, and we appreciate everything that you all do. Thank you and take care.
There are no other callers wishing to provide neutral testimony at this time.
Thank you so much. That brings us to the conclusion of testimony. Unless the bill presenters have any closing remarks, that brings us to the conclusion of our hearing on AB 283. I will close the hearing on AB 283. Congratulations to Senator Ellison on being the last one standing on the dais, along with me here. But jokes aside, please, I want to reiterate, do not infer a lack of interest or respect from my members who are not here. They have to go to other committees, they have to present in front of other committees, and I appreciate everybody accommodating the crazy scheduling challenges that we're all facing during this time of session. So with that, I'll move on to the final item on our agenda for today. That is public comment. Anybody wishing to give public comment in person is invited to the front of the room here in Carson City or in Las Vegas now, and we will start in Carson City.
Thank you, Chair Scheibel. Senator Ellison, wow. This is a first for me, only having 2 members, so I'm going to try to make it brief. I originally wanted to present something to you today, but because the committee's not here, I'm going to just postpone it, but I do want you to take this into consideration, what I'm about to say. That on March 13th, under Veterans in Politics talk show, Justice Cherry, retired Chief Justice Cherry, appeared, and he was questioned during the Fred Steese case. And Cherry had some information that was very telling, in which he said, and he agreed, that it's a crime to withhold exculpatory evidence in a criminal case, and that prosecutors won't prosecute prosecutors, and that the state bar won't go against their own. And I see that because when you're dealing with people, and this is what we were going to present to you today, but we'll save it for a different day. We've got instances where prosecutors have withheld exculpatory evidence and nothing happens to them. And one was a sexual assault, and we have the case and so on and so forth, and Ms. Grant was going to speak to that, but we'll do that another day. But what we were going to present to you was on the 18th, April 18th, I filed a complaint with the Attorney General's office on their pattern or practice. And what it deals with is that in 2022, I filed a complaint with the Sparks PD, Reno PD, and the Washoe County Sheriff's Office. It was to do an investigation, or actually lack of investigation. The practice and policy of the District Attorney's Office, Washoe County, is that if you want a review of your wrongful conviction and you claim a Brady violation, you will get no review. But if you do not claim a Brady violation, you get a thorough review. And that goes against their policy. This was submitted to the police, the law enforcement agencies, in turn submitted to the AG's office in 2022. And for nearly 2 years, it had been sitting there. And finally, I got a decision, well, kind of a decision. And basically what they did was they said, go back to the Washoe County Sheriff's. Well, under NRS 289.110, you can't. The DA's office cannot investigate their own. It's the AG's office. So I filed a complaint with all the documents, which I will present to the committee. And I want you to take a look at it. And it's the struggle that people like myself, of loved ones who've had wrongful convictions, and what they do. And I will tell you that there is a local news station that is very interested in looking into the Washoe County DA's office and the CIC, and they're getting other cases. And it's an ongoing thing. And you will hear prosecutors, even to this day, come to you and lie to you about my case and other things. And it's all documented, and I have videos of this on how they manipulate the system. And when you are making these kinds of decisions, please think about what I and others who've been wrongfully convicted, the families, what we go through, and how we still struggle to this day, and the laws that the DAs will give their narrative. And it's not right. Some of that is inaccurate, but they want you to believe what they tell you. Thank you.
That is okay. You are always welcome here in public comment, and we appreciate your time and dedication. I don't see anybody coming forward in Las Vegas to give public comment, so we'll go to the phones for any public comment this afternoon.
Thank you, Chair. If you would like to provide public comment today, please press star 9 to take your place in the queue. There are no callers wishing to provide public comment at this time.
All right, then that brings us to the conclusion of our meeting today. Not exactly sure who this announcement is for, but we will be meeting at 2:30 tomorrow instead of 1 p.m. So that is to accommodate the fallen law enforcement officers memorial ceremony occurring out on the quad, the area between here and the Capitol, which begins at 1 p.m., same time we normally start. So we will be here tomorrow at 2:30. Until then, we are adjourned.